I beg to mention item 3, my lord. Can the matter be taken up next Wednesday, my lord? In fact, I was supposed to file an affidavit in reply. That is ready, my lord. I'll be filing it within 1 hour.
The request
the
of
concept of
Mr.
that.
R. Day, matter stands adjourned for 1 week, enabling him to file the reply affidavit.
May I please, your lordship? Lordship, I beg to mention item number 11, lordship. Lordship, here my senior is unable today. Can this matter be taken in the next week?
Item 11 adjourned for 2 weeks.
Oblige, your
Your
lordship.
name?
P. Mojumdar, lordship.
The request of Mr. P. Mozumdar, learned counsel appearing for the petitioner.
Oblige, your lordship.
May I please, your lordship, my lord, I beg to mention item number 18, my lord. I am for the health department, my lord. I have taken consent of the petitioner, my lord. This matter may be adjourned for 2 weeks, my lord.
Why?
My lord, actually, my lord, the conducting counsel, Mr. D. Upamanyu, we could not locate the file yesterday. His father has suffered a mild heart attack yesterday. He has been, so he could not come to the same. We could not locate the file my lord, yesterday.
Mr. P.P. Bora, learned standing counsel help, submits with the consent of the counsel for the petitioner that the conducting counsel, Mr. D. Upamanyu,
The file we could
Is-
not locate.
not available because of personal reasons. Therefore, the matter stands adjourned. Matter is praised for an adjournment for 3 weeks. Prayer is allowed, list after 3 weeks.
Oblige, my lord.
May I please, I beg to mention for listing, my lord, one case, my lord, matter relates to non-payment.
What matter?
Matter relates to non-payment of AR salaries, my lord.
For admission?
Yes, my lord, on 22nd.
Date will be given by the court master. Leave it. Give it to him.
Oblige.
With regard to item number 13, your lordship, I have the sample prayer
Item number?
13, 1-3.
Yes.
Let the case be listened after 2 weeks, your lordship. We have some difficulty today.
Consent for the petitioner?
Taken, yes. I've taken,
Mr. Doctor,
yes.
learned counsel for the
Respondents wanted.
respondents, submits with the consent of the counsel for petitioner. The matter be adjourned for 2 weeks. Prayer allowed, list after 2 weeks.
Most obliged. Your lordship, I have a similar prayer with regard to item 60, your lordship. Let them matter may come up after 2 weeks, your lordship.
60.
60, so content matter. I've been
You have
Instructed by
to
the
take the
conducting
consent of
counsel.
the counsel for the petitioner. We don't know what is there. Have you
prayer for
taken?
the petitioner, your lordship.
Huh?
It's a prayer on. behalf
You
of
are for the petitioner.
Yes, sir.
Item 60.
60, content prayer.
Item 60, but your name is not reflected here.
Our Wakalatama has not been.
Mr. Dr. Learned counsel for the petitioner submits that he has recently been engaged in the matter. He requires some time to complete his instructions.
after
Matter
2 weeks.
stands adjourned for 3 weeks.
Masum.
I want to mention, your lordship. If you are in respect to item number 17, your lordship, I have to file everything reply 2 weeks time may be granted, your lordship. I am for the petitioner.
Who's for the petitioner?
I am for the petitioner.
You are for the petitioner.
Item 17, one sir.
Learned counsel, Mr. Islam, appearing for the petitioner, prays for and is granted 2 weeks time to file the reply affidavit. Prayer allowed, list after 2 weeks.
Oblige.
Lordship. In this case, Lordship, implement return Lordship, and all our container has been transferred Lordship.
All
All our container has been transferred Lordship.
has been?
Transferred.
I heard Learned counsel issue notice returnable 2 weeks. Steps on the opposite party by registered post AD within 1 week from today.
Oblige Lordship.
List after 3 weeks. Yes.
Please, your lordship. My lord, matter basically pertains to, my lord, non-payment of area salary as well as current salary, my lord, despite of their service being regularized, my lord, with effect from, my lord, 28/2005. Here, my lord, petitioners, my lord, are the still teacher, my lord, who were appointed in the ME schools, my lord, in the Kasar district. And their appointments were issued by the district elementary education officer Kasar, my lord, on 29/11/2000, sorry, 1994. Therefore, my lord, some their appointment were cancelled and they had appeared approached before this court, filing a civil rule number 324 of 95. And accordingly, court by its order dated 21/1995, it directed the respondent not to ask the petitioner and also to pay the regular salary. My lord. Thereafter, my lord, subsequently, my lord, their service were reinstated. My lord. Subsequently, my lord, the chief secretary, my lord, of the Government of Assam, my lord, had notification dated 9/9/1996, my lord, had directed.
You are
conduct-
appointed by which order?
My lord, order is at page, my lord. Page 30, 37, my lord. And just this is the type copy and Bhanagulu will find it. Page, my lord, 30.
This is the order which was directed to be inquired into by CID by an order of this court.
Oh, my lord, your lordship is asking for the orders of the court, my lord. No, my lord.
I am asking you for your appointment order,
Appointment, my lord, regularization order is at page 37, my lord.
regularization order.
Yes, my
So this regularization order
lord. My lord.
by an order of this court on
Right.
8/6/2022,
My lord.
there is a direction to the CID to inquire into the authenticity of the order.
Yes, yes. That is only with authenticity of their order, my lord.
So what is the status?
Now, like, they had, my lord, in fact, filed an affidavit, my lord,
Hmm.
saying that, my lord, they are not on the authenticity of this order, my lord. They are saying that, no, some of the petitioners did not acquire the qualification of B.Ed or DLED, so they cannot be accommodated, my lord. Now, whether this order is authentic or not, my lord, that part the government keeps silent, my lord, in the affidavit.
Yes, who is for the respondent?
My lord, I am for the elementary education department. My lord. We have filed our affidavit, my lord.
Hmm.
Here, my lord, kindly see page 63, my lord, start from, my lord, here. Of our affidavit, there are 6, my lord.
Hmm.
A screening committee was constituted for, my lord, selecting the illegally and irregularly appointed teachers, my lord. Here, my lord, may I read para 7, my lord? Advertisement for screening applications were received from illegal irregular appointed teachers for the state. After conducting preliminary examination at the directorate level, the elementary education department by notification dated 4/6/2001, my lord, constituted 5 screening committee headed by the divisional commissioners concerned and principal secretary of 6 civil areas and BTC to examine those applications, and the report of the preliminary committee of the said 5 screening committee were Upper Assam Division, number 2, Lower Assam Division, number 3, North Division, and Hillberg Valley Division, and BTC. Here, my lord, 4 category has been created, my lord. Recommended and working till date. There are 136 number of teachers, and category 2 recommended by but discontinued job 250 there, and third category not recommended but working
Now the
till.
petitioner falls under which category?
My lord, kindly see para 9, my lord. Who were not recommended till that sir, state restaurant decided to issue individual supporting them. The emergency.
The petitioners fall under which
Malad-
category?
My colleague said para 12, my lord. Answering to humbly begs that the name of the petitioners in the present petition, except petitioner number 10, 12, 13, 17, 18, 19, 20, 19, 22, 23, 26, 28, 30, 40, 41, 44, 47, 50, 52, 55, 57, 59, 60, 5 to 71 and 75 were found in the screening committee report under Kasar district, but they have not fulfilled the criteria
of receiving salaries up to 2007 and onwards and having JBT, DLAD, etc. as laid down in the cabinet memorandum. Hence, they could not be recommended as tutor or teacher.
What is the meaning of criteria for receiving salary means?
My lord, as per my lord, cabinet decision, my lord, they should have to receive salary till.
Where is the cabinet decision?
This is
It's 74, my lord.
Page
74. sir.
74.
May I read it, madam? Regulation of irregular,
Yes.
illegal, regulation of irregular, illegally appointed teachers of lower primary and upper primary schools by creating supernumerary personal posts. My lord, introduction of background, a large number of the teachers were appointed irregularly in lower primary and upper primary school all over the state during the period of 1989 to 1991 to 2001, more particularly in Dhemaji, Lakhimpur, Sibsagar, Kasar, Karimganj, Hailakandi, Bongaigaon, Nalbari, Dibrugarh, Jorhat, Golaghat, Nagaon, Morigaon district by some ill-level officers and school managing committees without following the provisions laid down in the Assam Elementary Education Provincialization of Service Act 1974, as well as the rules of 1977. In terms of the Honorable High Court, in a Honorable Court final order dated 2/3/2010 passed in WBC number 1048 of 2004, the Elementary Education Department placed the matter of regulation of irregular teachers before the cabinet in its meeting held on 26/2/2011 with a view to examine the nature of appointment, status of post, working status of salaries, academic qualification, etc. The Director of Elementary Education Assam invited application from these illegally appointed teachers during 1991 to 2001 throughout the state by an advertisement dated 1/2/2012 and 4/2/2012 in local newspapers. In response to the aforesaid advertisement, applications were received from such category of teachers. After preliminary examination of the applications so received at the directorate level, the Elementary Education Department constituted 5 screening committee headed by the divisional commissioners concerned of the principal secretary of the 6 scheduled areas to examine these applications. Preliminary committee's report. After the detailed and thorough scrutiny of the records and also after aforesaid personal hearing of the applicants and screening, the screening committee submitted the report to the government. After examining the government level, the following facts have been noted. A large number of candidates were appointed on 6/12/1999 at Sibsagar, Nalbari, and Lakhimpur district. That is the very day on which ban on appointments were issued by the government. B. A substantial number of candidates from Nagaon and Morigaon districts were appointed by the school managing committee of the schools, but according to the provisions laid down in the Assam Elementary Education Provincialization Rules 1977, SMC had no power to appoint teachers in the provincial school. C. All the candidates were appointed against non-existing posts, that is the excess of existing posts. D. No records regarding appointments, proceeding books, select lists, etc. are available in the district concerned. E. Most of the irregular teachers were found to be irregular in attendance in their respective schools. F. Most of the teachers did not receive salary right from the date of joining, and some received salary up to the certain period only. All salaries were discontinued since 2007. Only the teachers of Sibsagar district received salaries up to February 2012 by creating supernumerary posts. After scrutiny of the report of the screening committee, the final outcome is as follows. Category 1, recommended and working till date, 136 persons. Category 2, recommended but discontinued with the job, 250 persons. Category 3, no recommended but working till date, 8,470 persons. Category 4, no recommended and discontinued with the jobs, 2,900 persons. Based on the report of the screening committee, 136 teachers, category 1 above, have already been regularized in service. It is pertinent to mention here that in addition to 8,470 teachers under category 3 in respect of 752 teachers of Dhemaji and
Now,
Lakhimpur-
this is approved
My
by the
lord.
cabinet.
My lord,
Now, the petitioners fall under which category?
my lord, here, my lord, F, my lord, kindly see. Most of the teacher did not receive
My
salary.
lord,
My lord, that means that petitioner is not continuing his service
my lord,
and he
there-
has not received
in the
salary.
Cabinet memorandum, my lord. There is not mention of Kasa district.
Hmm?
No Kasa district is mentioned. my lord. They had conducted inquiry only pertains to my lord Shivsagar, Nalbari, my lord, Nagaon, Morigaon.
Where do you find it?
Dhemaji. And this is the districts, my lord, they are mentioned, my lord. Page 74, my lord, one paragraph A, my lord. A large number of candidates were appointed on this matter at Shivsagar, Nalbari and Lakhimpur district. And para B, my lord, Nagaon and Morigaon.
Kindly see, my lord, the initial background, introduction and background. A large number of teachers were appointed irregularly, illegally in lower primary and upper primary schools all over the state during the period of 1989 and 1991 to 2001. More particularly, Dhemaji,
Akshar is included.
my lord.
Yeah, Kasar is included, but they have conducted this inquiry, my lord.
Huh?
They record collected, my lord, kindly see for A and B, my lord.
A and B
Only
of,
this district, my lord. They have mentioned all the districts, my lord. And moreover, my lord, this is the memorandum of 2000, my lord, 20.
yeah, A and B of 74.
Yes, my lord.
Ah.
They pertains to only the confined to the district, Shivsagar, Nalbari, Lakhimpur, Nagaon and Morigaon.
Here, my lord, a large number of candidates were appointed on 6/12/1999. Only this particular date, my lord, before the ban start, my lord.
Now, my lord,
Nalbari, except a very,
No,
Very
their service was regularized on.
whatever the cabinet has taken a resolution and has categorized the teachers.
Right.
Some who have been receiving salaries and have the basic qualification,
My,
they will be continued.
my lord.
Some who has been receiving salaries but does not have the basic qualification, they will be treated as tutors.
Now, my lord, the regularization order of the petitioners, my lord, that are also in person of the cabinet decision, my lord. Whether that cabinet decision was set aside or not,
No,
that
no.
was not never mentioned, my lord. And moreover, particularly this order,
Have you challenged the cabinet decision?
this cabinet decision is not understand because my
Then-
cabinet decision is still existing, my lord.
That's right. So to,
And so far, my lord, this order of my
no,
lord,
but there has to be some purposive construction.
my lord, kindly see, my lord, the order, the honorable court's order, my lord, in the year, my lord,
Hmm.
I am mentioning, my lord, in the year 2022, my lord, last year order, my lord, screening committee, my lord.
No, on the court's order is for to find
The
out.
authenticity of this order has not yet told it before this court, my lord. Whether this order, my lord, is authentic or not, my lord. That
This
was yet-
authenticity of the order will have relevance only if read up along with the cabinet memorandum and the
But
cabinet
cabinet-
decision taken.
Cabinet memorandum subsequent. my lord.
Maybe, but assuming the order is not authentic, then then you have no legs to stand.
My lord, until and unless this order is found to be, my lord, illegal or, my lord, unauthentic, my lord. Then cabinet decision will, my lord, will come to force, my lord, in my case.
You show me any authority on that.
My lord, right now, my lord,
You show
I
me.
am only, my lord, on salary, my lord.
That is what I am saying, that to say that this cabinet proposal or is not applicable in your place, there must be some challenge to this. Your case has to be challenged
My
that
lord, my lord. Yes, yes.
your
Hmm.
case is covered by the earlier cabinet decision,
yes.
not by this cabinet decision.
And in fact, my lord, I have stated in my affidavit reply also, my
Where have you made out that case?
my lord, in my affidavit reply, my lord,
Uh, All right, then we'll require hearing, proper hearing. We'll admit it,
my lord.
admit, Hardler and councils admit. Be listed for hearing. We'll have to hear
Right.
on this.
Bless.
Obligement.
My lord, this matter has come up after almost 1 year. There was a direction, my lord, to produce some records. Records were with us, my lord, but since this official records and matters not listed, we had to send back. My lord will grant me
What
some.
is the matter about?
It's some regarding my compassion appointment. This person petitioners was rejected and I was asked to produce his financial credentials, my lord. Comparison sheet.
Credit statement I am having lordship.
Sir.
You have it.
Yes, lordship.
Those, yeah.
Rejection is at page 38A, lordship, annexure 9.
Yes,
The rejection of the DLC minus, lordship, in the petition, page 38A.
what is the name of the petitioner?
Name of the petitioner.
Arunavati.
Arunavati.
Just married woman. Oh, নাম তো করতে পারি।
So her financial status is better.
Better, lordship.
Yes, madam.
Lordship. I have, I have approached for compensation and appointment, Lordship. Lordship. Already I
Your
have
case
had
has not been considered because your financial
Financial status.
status is better, shown to be better.
Yes.
So that is one of the criteria.
Yes.
So the person who was appointed, your financial standing is better than the respondent number 5. Therefore, the respondent 5 was appointed. So what more is to be done? This is rejected by whom? DLC.
District level committee, lordship.
Huh?
DLC.
DLC, lordship. IT rejected, lordship. In our affidavit also, we have stated, lordship, the petitioner financial condition is higher, lordship. Better.
They've taken a conscious decision
Lordship.
that the person, other person's financial condition is, she's in a weaker financial condition.
You should kindly pass over the matter for time being, Lordship. My senior is in left.
We are keeping this here, retaining, or you take it back, give it to us
Lordship.
on the next date. Your senior will be here
Yes, Lordship.
at 2 o'clock,
Obliged.
at 2.
Lordship.
But ready.
We have been recently engaged in this matter, Lord. And it may be posted in the next week so that I may be able to obtain instructions.
My lord, let this matter may come up after 2 weeks, my lord. I am also appearing in this matter, my lord, for the first time. And I have, my lord, checked that we haven't filed any affidavit in this.
Yes,
So I will also have to file an affidavit in this matter, my lord.
A joint request matter stands adjourned for 2 weeks.
they may file the affidavit in the meantime. Oblige.
Yes.
May I please, your lordship. Lordship, this was regarding non-payment of salary.
Sorry, information regarding the present status of the case, my lord. So sometime I'll be allowed for instruction. My
What is your prayer?
My lordship, my salary for the month of October and November was not paid to me. As it was that I was on unauthorized leave, but that was not the case. My situation was such that I joined in the year 2014. And in the year 2016, my father-in-law had a cardiac arrest. So preliminary treatment was taken in Narayana. Thereafter, he was referred to Apollo in Delhi. So I had to take him to Delhi.
You're still working.
No, lordship, I'm not in the department now. Recently, I have found some other job. The case has been pending since then, but
So your representation is pending.
lordship,
We'll direct the authority to dispose of
lordship, that
the representation. Heard learned counsels for the parties. The petitioner before this court. At the relevant point in time was working as a district coordinator. Within bracket RBSK / WIFS / ARSH bracket closed under NHM and was posted in Amingaon. Stop. Petitioner joined in her services in 2014 and has been rendering her services. With utmost sincerity. Stop. Because of some medical ailments that the petitioner suffered, she was absent from her duty on 10/11/2016 to 11/11/2016, and which was subsequently extended as she could not recover as she did not recover from the ailments. Stop. This was intimated to the Joint Director of Health Service by communication dated 15/11/2016, as well as through an email to the Additional Deputy Commissioner, who's the nodal officer, RBSK, State Consultant RBSK, District Program Manager. Stop. Thereafter, she had to go out of station again from 12/10/2016 to 18/10/2016 for treatment of her father-in-law. And thereafter, 8/10 and also from 8/10/2016 to 11/10/2016 because of medical reasons, and which intimation she had communicated to the Additional Deputy Commissioner and Joint Director by email dated 13/10/2016 and 15/10/2016. Stop. It is the petitioner's case that There was no lapse on her part, except for the fact that she was suffering from some medical ailments and therefore was unable to attend to her duties. Stop. The grievance of the petitioner is that her salaries for the months of October and November 2016 was never released. Stop. Although she had repeatedly sought for the release of the salary by from the authorities concerned, but no such salary was released. A show cause notice dated 26/12/2016 was also issued, asking her to show cause as to why she was unauthorizedly absent from her duty since 10/11/2016. Stop. In response to this said show cause, she submitted a reply on 5/1/2017, giving detailed reasons as to why she could not attend to her duties. Stop. However, what happened to the, after the reply, what happened?
Worship, for the reply, again, I have to file a representation before the mission director.
No, after the show
The-
cause, was any proceeding initiated?
Nothing. Worship.
After the reply furnished by the petitioner, no proceeding was initiated against the petitioner. Stop. But the salary as prayed for the months of October and November 2016 was not released. Stop. Petitioner preferred yet another representation dated 8/3/2017 before the mission director, National Health Mission, Assam, praying for release of her salaries. Stop. However, no reply was forthcoming from the department, nor her salaries were released. Stop. Aggrieved, she has approached this court filing writ petition, praying for appropriate redirection or order. This court, by order dated 12/6/2016 to 17, issued notice. Stop. No response has been filed by the petitioner, by the respondents. Stop. The matter was last listed on 7/12/2020. But today also, when the matter is called up, MSO and so Learned Standing Council NHM submits that she would like to go, she prays for further time for completing her instructions. Para. Having heard learned counsels for the parties and upon perusal of the writ petition, it is found that the only grievance of the petitioner is seeking is for release of her salaries for the month of October and November 2016. Stop. From the documents enclosed to the writ petition, it is seen that the petitioner was absent from her duties, citing medical reasons. Stop. A show cause notice was also, show cause notice dated 26/12/2016 was also issued, to which the petitioner had submitted a reply. Stop. As submitted by the learned counsel for the petitioner, no proceedings was initiated against the petitioner. Stop. No order has been passed by the competent authority negating the prayer made by the petitioner for release of her salaries, area salaries. Stop. The respondent also has not furnished any reasons nor filed any affidavit contesting the claims of the petitioner. Stop. Considering the fact that the matter has been pending before this court for some years, for some time, and also taking into account the prayer of the petitioner being limited to release of area salaries for the month of October and November 2016. Coupled with the fact that the petitioner is no longer in service of the NHM as submitted by the learned counsel for the petitioner, this court is of the view that the writ petition need not be kept pending for want of instructions from the respondents. Stop. The writ petition stands disposed of with a direction to the petitioner, respondent NHM to look into the grievances raised by the petitioner by the representation dated 8/3/2017 stated to have been filed by the respondent, by the petitioner regarding a claim for area salaries for the months of October and November 2016. Stop. The respondent authority will call for any such information or document as may be felt necessary while deciding the issue from the petitioner, and if required, give a personal hearing to the petitioner. Stop. The respondents will thereafter pass appropriate orders in response to the prayers made for release of area salary for the months of October and November 2016. Stop. If the respondent authority considers it necessary not to release the area salaries as prayed for partially or in full, then the same must be supported by adequate reasons. With the above observation, writ petition stands closed. The authorities will carry out the exercise within 30 days, 60 days from the date of receipt of a certified copy of this order. Writ petition stands disposed of, interim order, if any, stands vacated.
Worship, my name may be reflected.
Name of the company.
Deep double.
Please, your lordship matter may be adjourned for a week, lordship. I'm
Why?
praying on behalf of KDP lordship. Matter may be adjourned for a week.
Why? You don't want to press the matter? Who's for the respondent?
I am appearing for the respondent. Lordship.
Any instructions?
No, Lordship.
Why?
They have come against a order dated 7/7/2015, which is at page 36, Lordship.
private respondent is also there, whether service has been completed or not.
How was the selection made?
So after advertisement Lordship,
But how? On what basis?
advertisement is at page 15, Lordship.
Then select list.
Select list is at page 25, Lordship.
Where are the minutes or selection order? You produce the selection minutes
Lordship.
Friday.
Can it be on next week, Lordship?
All right, 20, list on 20.
Of like
On which date the Learned Government Council, Mr. Sharma,
SR Borwa.
SR Borwa, will produce the minutes of the selection and other connected records pertaining to the selection of the petitioner, selection of the private respondent in response as what was he appointed? Anganwadi worker
Anganwadi worker.
pursuant to the advertisement dated 10/9/2009. The respondents are directed to ensure that the records, relevant records, are handed over to the Learned Council for perusal of the court on the next date fixed. List on 20.
Of like
MS so-and-so appears for the petition. Yes.
My lord, matter is regarding compassionate appointment, my lord. And my lord, my application was rejected, my lord, on the ground that less than 3 years.
3 years.
My lord.
What is the status again?
My lord, rejection was on 2 grounds, not 1 ground, my lord.
Where is
That-
that order?
My lord, page 34, my lord.
32.
Page 34, my lord, of the writ petition, serial number 12.
32.
Page number 34 is the relevant portion, my lord.
Hmm. Farooq
Serial
Ali.
number 12,
Farooq Ali.
Farooq Ali, the writ petitioner, my lord. My lord will find on 2 grounds, it was rejected. The applicant passed HS and applied for the post of pump operator and could not consider due to want of vacant post. This is the primary ground, my lord. And yes,
No, but if it is on the lack of vacancy, then the second condition is irrelevant.
irrelevant. That is what, my lord.
But is it because of the first condition?
First condition, there, my lord, unless there is a vacancy, where he will be put? That is,
Where is the vacancy position?
My lord, vacancy position is
Under which district is it?
what better, na?
here, my lord.
Executive
Vacancy, my lord.
engineer.
One person was appointed also. my lord.
Executive engineer. PHE.
Yes.
Where is the vacancy position?
My lord, page 33, my lord.
33, yes.
3,
One post.
yes, one.
Who was appointed?
My lord,
Respondent number
private
5.
respondent, my lord.
Where is his name?
My lord, Pankaj Das, my lord.
Hmm?
You know, my
Pankaj Das.
respondent 6, my lord.
No, how his case was considered?
Pankaj Das got grade 3, whereas he has applied for grade 4.
My lord, this is a wrong submission, my lord.
Where is your application?
My lord, my application is, my lord. Paste with my lord. my lord.
Twenty-one,
Yes, my lord.
pump operator.
My lord, this is the designation of the employee. My father was, my lord, pump operator.
Or is
Designation
it
of
a
the-
grade 3 or grade 4?
my lord,
Grade 4, my lord, pump operator.
my lord, only because my father was grade 3, my lord, it doesn't mean that I have to appoint my lord in that post only, my lord. There is no, my lord, such condition.
And my lord, he was
No,
HS
no.
pass.
If you look into the vacancy position,
Yes, my lord.
there is only one post,
Yes, my lord.
that too in a grade 3.
Yes,
Grade 3.
Now, unless you say that pump operator is in grade 3
my lord.
and your case was considered against that grade 3,
My lord.
only
My lord-
then we can look into what reasons are.
No, my lord, I have not applied. My father died, my lord.
Mr. Council, understand there is only one post
Yes, my lord.
in grade 3.
Yes, my lord.
Now, you had applied for that post.
Yes, my lord.
You have mentioned here, you had applied for a post.
A post, my lord.
What is your
Malab,
requirement higher secondary?
My candidature could have been, my lord, considered.
Higher secondary.
Yes, my lord.
What is the candidature of the other person?
And my lord, higher secondary is, my lord, the qualification required for grade 3, my lord.
Hmm?
I'm qualified for appointing as grade 3, my lord.
Mr. Dhar,
My lord,
we'll need the proper selection, how it was made. This is by DLC.
DLC, my lord.
And
How
my-
it was made?
And my lord,
Serial number 1 was appointed. And all the others were rejected, saying that there is no vacant post. Serial number was appointed in that one vacant post.
Yes.
Now, whether his candidature was considered vis-a-vis the other candidates doesn't appear to be. And it says that he applied for pump operator,
my lord, I have given my.
but his application doesn't say so.
Yes, my lord, there is no, my lord, provision for, my lord, giving any preference.
He says his father was a pump operator.
This is the requirement of this application, my lord. That is why I have stated that.
You get the details as well as the financial conditions.
And my lord, moreover, my lord, when the selection was made, my lord, already more than 2 years, my lord, was over, my lord, regarding this private respondent, my lord. And my lord, if somebody's application could not be considered within 2 years, my lord,
See, these matters should not be kept pending. Why? For instructions, you call the officer, who is he? Who is the person who has passed it? Call him with all the records. Call him to the court for assistance. Who has furnished these records? Chief Executive Engineer.
My lord.
Mr. Counsel, you can't be so helpless.
No, my lord, these.
If you are helpless, then we'll be compelled to help you.
No, my lord. These comes from
Hmm.
the department, my lord. PHE.
That is what I'm saying. You are appearing for PHE.
No, I'm not appearing for PHE. I am for the DFC, my lord.
Who's for PHE? Yes, Mr. Gogoi, where were you hiding?
I'm not hiding, madam. DLC, madam, this sits under the chairmanship of the DC, madam. So only position we are asked. We are not, the executive engineer only gives what is the.
No, first thing is whether pump operator, see, come to page number 22.
No, it's not about pump operator. A person who applies for compulsory appointment, it either can be by the going by the OM, it can be either grade 3 or grade 4. What he has to, this private respondent to establish that his qualification is higher than this person.
That is for you to decide and
Madam.
say.
We don't decide, madam. This is DC which scrutinizes
No,
everything. madam.
correct, DC will decide,
Yes,
but DC will decide on the information furnished by you. So what information went from your
We
office?
just gave, my lord, what is the vacancy position?
That's all.
That's all, madam.
So Mr. Dhar, Mr. Gogoi has not been able to help you.
Particulars has to come from the department, my lord.
Huh? No, you call for the records, we'll see. Call for the records of the DLC. Immediately.
Records will reveal everything, madam.
Had learned counsels for the parties. This writ petition is filed by the petitioner praying for our compassionate appointment. As his father, who was serving as a pump operator under PHE. Which PHE?
my lord.
Borpeta.
Borpeta.
Under executive engineer PHE Borpeta,
Borpeta.
when he died in harness. Stop. Petitioner's grievance is that his application for compassionate appointment was rejected. And the private respondent, have you added him as a respondent?
Yes.
Was appointed. Stop.
Vacancy position report is like.
The minutes dated petitioner's grievance is that his case was rejected by the DLC
No, Polo, 23.
by minutes dated 4/7/2017. Stop. A perusal of the minutes, impugned minutes reveal that the private respondent was appointed, was recommended for the perusal of the minutes reveals that there is only one vacant post shown in grade 3 under the office of Executive Engineer PHE Borbera. Stop. The private respondent was recommended for appointment against the vacant post under grade 3. Stop. The petitioner along with other candidates. The petitioner's case was rejected on the ground that he had applied for the post of pump operator, and the same could not be considered due to want of vacant post. And further, that the remaining period of service of the deceased, namely late father of the petitioner, was only 10 months. Stop. Learned counsel for the petitioner has referred to the application filed by the petitioner before the authorities seeking compassionate appointment, which is available at Annexure 3, page 22 to the writ petition. Stop. A perusal of the said application does not reflect that the petitioner had applied for the post of pump operator, which is found recorded in the minutes of the DLC insofar as the petitioner is concerned. Stop. That apart, it is not clear from the minutes whether the post of a pump operator is in the cadre of grade 3 or grade 4. Stop. The minutes also does not reflect the manner in which the selection was made. For recommendation. Minutes also does not reflect how the recommendation was made, whereby the case of the private respondent was recommended for appointment. Stop. Minutes reflect as many as 16 candidates were considered. Stop. The private respondent's name is found at serial 1 and the petitioner's name is found at serial number 12. Stop. The private respondent was recommended. All other candidates, including the petitioner, were rejected. Stop. Whereas in that view of the matter, the respondent authorities, more particularly the chairman of the DLC, namely the Deputy Commissioner Borbera, to furnish the relevant records of selection, records on the basis of which the recommendation by the DLC was made in favor of the private respondent. Mr. Dhor, learned counsel, government counsel, additional senior government advocate appearing for the respondents. Respondent number 1, 2, and 4. And Mr. T. Ugoy for respondent number
My lord, time for 3, my lord.
3 and
5.
5. Anyone for
And five for number 6.
Mr.
And how?
N. Hawk for respondent number 6?
Already my lord, SLC has approved. Appointment has been.
Mr. Hawk, learned counsel submits appearing for 6. Respondent number 6 submits that the appointment, he is already appointed. That pursuant to the recommendation of the DLC, the petitioners, the respondent number 5's case was also recommended by the SLC and he is since been appointed and is working under the department. Stop. Let the records as directed be produced before the court on the next date fixed. Tell us when you want to produce list on 25th September.
All right.
We are claiming compassionate appointment, my lord. My father was appointed as a junior assistant in the amalgamated establishment of the deputy commissioner, Dorong at Mongoldo. Now, he died while in service on November 2010, and I applied within 2 months, but I being a HS qualified person, I applied within 2 months. Now, it was placed before the DLS. My lord. May I take your lordship to page 20, the minutes?
Page
20, my lord, the minute. This is dated 1/10/2016, my lord. The relevant portion is at page 24, Sabir Ahmed, serial number 24, page 24, serial number 24. Serial number 24, Sabir Ahmed. The ground of rejection, my lord, has been shown that there is no vacancy for the post of junior assistant. While I applied for any post, I didn't mention any particular post or either the post of my father. Now, for vacancy, my proposal was rejected, and it was stated that certain matter was pending before the High Court. That's why there is no recruitment, my lord.
Hmm.
Now, immediately thereafter, my lord, this minutes was dated 11/11/2016. And in the month of June 2017, an advertisement pops up for the post of junior assistant. My case is that, my lord, these vacancies were certainly there. It could not have been created.
No,
within-
vacancies for compassionate appointment.
Yes, my lord, there's a difference.
There may
my
be
lord.
vacancies
Yes.
otherwise.
This was advertised, my lord. and
There may be
definitely they-
vacancies otherwise.
Yes,
All vacancies are not available for compassionate appointment.
correct, my lord.
5%.
But the ground of
okay,
rejection, the ground they say that because of a particular case, the recruitment has been stopped. Again, contrary.
What
to
is the status of this case?
My lord, perhaps it is not no longer pending because the
What
advertisement. is
perhaps
now there.
you should have found out what is the status of the case, what orders were passed.
My lord, the advertisement comes up after a couple of months, my lord. The advertisement is at page 26. This itself.
See, your claim that because of this advertisement, this is a false statement on the face of it is not acceptable on these limited facts. Because there is a reference of a writ court order.
Fine.
You have to find out the status.
But the recruitment which they points out, that very advertisement is published in the month of. June
Maybe, may not
2016.
be for, you'll have to link up on the basis of the orders that may have been passed.
My lord, I'll place that, my lord. I'll bring it on record. my lord.
You should have already brought it on record if that is your case. That because of the pendency of the case, the proceedings were stalled and subsequently they turn around and give an advertisement.
I'll bring. it on
Without
record.
knowing what orders have been passed by the court, maybe it is the court's direction to advertise the post. Then
But then again, my lord, the compassionate post. cannot
you
be linked with-
see, vacancy by itself is not available. It has to be earmarked for
Fine.
compassionate appointment.
Yeah.
So the posts which are otherwise available outside this 5% can be filled up by regular recruitment process.
Correct, my lord. Then the ground of rejection itself goes, my lord.
How?
Because they say that the.
They
recruitment
say
is
that
being
there is
stalled.
no vacancy against compassionate posts.
And then there's very second line, my lord. They say that the recruitment is being stalled.
That you don't know because you have not produced that order.
I'll place that on record, my lord. Otherwise, from 2017
The case
onwards,
was
my lord,
dismissed
the-
for non-prosecution, Lord, in the month of 2018. And that particular petition, Lordship,
Dismissed.
dismissed for non-prosecution in on 6/4/2018. I just check it out.
You have a copy of that order. It has not been restored.
That information I do not just check in the system, Lordship.
Mr. Bharadwaj, learned counsel for the petitioner, submits that the case of the petitioner was rejected by DLC
by deals.
DLC.
by its minutes, by its meeting held on 1/10/2016, where in respect of the petitioner, whose name is found at serial number 24, his proposal was rejected on the ground that there is no vacancy against compassionate posts. And thereupart, because of the pendency of WPC 7318 of 2013 within bracket 3 Dibyajyoti Dekha versus State of Assam and others, the process of recruitment of junior assistants have not yet started. Stop. Mr. Bharadwaj submits that thereafter, by advertisement dated 2nd of June 2017, 12 number of posts of junior assistants have been advertised. Stop. He submits that this action of the department is not supported. The rejection of the case of the petitioner is not supported by the subsequent action of the department, whereby 12 number of vacant posts of junior assistants have been advertised. Under the establishment of Deputy Commissioner Dorong Moldoi. Being aggrieved, he has preferred this writ petition. Mr. Borua, learned government advocate, submits that as per his information, the writ petition 7318 of 2013 has been dismissed for non-prosecution. Do you have the order? Date of the order?
6/4/2018.
By order dated 6/4/2018.
18.
Stop. Mr. Bharadwaj submits that he will place before the court the status, place before the court any subsequent orders that may have been passed in the said writ petition, and thereafter the matter be taken up. Mr. Borua, in the meantime, is directed to obtain instructions as to the number of vacancies that may have been earmarked for compassionate appointment under the office of the Deputy Commissioner Dorong Moldoi. The vacancy position under the office of the Deputy Commissioner Dorong Moldoi, including vacancies that may be available for compassionate appointment for the relevant years. The matter be listed after 2 weeks. Okay. Yes.
May I please, Lord? My lord, I applied for compassionate appointment, my lord, for the due to death of my father, my lord. So DLC, my case has been rejected, my lord, without assigning any reason, my lord. The response number 5 name has been, my lord, recommended for SLC's consideration, my lord. So my ground of silence, my lord, her appointment is that, my lord.
Where is the rejection order?
Lordship may annexure
Page
Yes.
18.
page 18, my lord, relevant portion, my lord.
Page
Page 18. Lordship may
18.
from 17, Lordship may but relevant portion is page 18, my lord.
Yes.
May I read from the last paragraph of the page 17, my lord, to release the rest of the
Yes.
paragraph. The committee also examined other 6 number of proposal that is Gulshan Begum, Jitu Das, Kon Kolita, Nihakanto Kolita, Manoj Kumar Das, I am the Manoj Kumar Das, Sri Bhaskar Das, against the total vacancy of 10 of grade 4 post in resulting from clubbing of grade 4 vacancies by Irrigation Rohingya Department. It is also noted that the candidates have submitted their application within the prescribed time limit, but the sponsoring irrigation office has taken time to process and place the same in the DLC. Hence, the application cannot be penalized for the official delay. So the DLC viewed that the case of the applicants cannot be rejected as a time bar, that is on the ground of 2 years have elapsed from the date of application until date of consideration by the DLC. Accordingly, took up for consideration, the Irrigation Rohingya informed that one post among the combined grade 4 vacant posts can be made available for filling up under compassionate ground, and accordingly, the case of MRS Gulshan Begum was Gulshan Begum was Nahar Begum was proposed for grade 4 post of peon. The DLC decided to forward her case for consideration by government for Irrigation Department and the SLC subject to the consent. This is my her name is problem. Only thing is my out of 6 my lord. So as per this my lord compassion appointment, they have to my lord while proposing her name my lord, recommending her name my lord, they have to compare with the others my lord, who is best eligible person and needy person my lord. Just forwarding her name my lord without minor making a comparative eligibility
Insofar as your name is concerned, along with others,
my lord.
they say that it has expired 2 years. It is beyond 2 years. Therefore, it was not considered.
No, my lord. Beyond 2 years, there's a all due to delay of the administrative office. It has been condoned, my lord. All have been, some have been beyond 2 years. They have been condoned, my lord.
By? Condoned by?
By the author DLC, my lord. They have accepted, my lord.
No. Kindly see in page number 18.
My lord.
In the, paragraph, in case of.
Maybe, my lord, my wrong understanding, my lord.
In case of Jitu Das, if you can find it.
My lord, irrigation, may I read from the above line, my lord? Nohar Begum, we mentioned so. The condition that
below that, in case of Jitu Das.
My lord, I am not Jitu Das, my lord.
No, I know. You can find your name is also there.
Manoj Das, my lord.
Yes.
My lord, rest are my lord because it is delayed, but they have filed the application within time. Delay of more than 2 years because of administrative, my lord.
No, you said DLC had condoned it.
Our also, when it is placed before the DLC, it is more than 2 years, my lord. So DLC will say that we are not condoning that part because it is an administrative delay, not on our part, my lord.
The minutes you are referring to are the DLC minutes only.
My lord.
Page number 16.
My lord, this is the, they have taken the different department, my lord. I'm only referring to the Rohingya irrigation department, my lord.
No, I know. But
resolution number 4, my lord.
No, these are minutes of DLC or SLC?
DLC, my lord. DLC, my lord.
So why do you say DLC has condoned? DLC is not condoned. It is what is reflected in that paragraph in page number 18.
My lord.
In case of Jitu Das, Konkon Kolita, so-and-so and Manoj Kumar Das, time period of 2 years has been completed.
Till the date of completion by them and accordingly took up the for consideration. Took up for consideration. That means my lord condoned. Date of application till that the consideration by the DLC and accordingly took up for consideration, my lord. Hence the matter applicant cannot be penalized for the official delay. So the DLC viewed that the case of the applicants cannot be rejected.
What is the response of the other side? government?
Your Lordship, second part is important, Your Lordship. My learned senior counsel was actually not stressing on that. I just want to stress on that. Delay has been condoned, but the ground on which his application was rejected because there is no vacancy. Only on the ground of vacancy. If I may complete that sentence, Your Lordship, in case of Jitu Das, Konkon Kulta, Neelakanta Kulta, and Monos Kumar Das, the DLC also noted that time period of 2 years from date of application has been completed as of today, and their cases have been duly considered and could not be recommended due to want of vacancies as per 5% vacancy criteria for compassionate ground appointment. And hence the cases need no further consideration, should be deemed to have lost ability. Only one post was there.
What is the meaning of that?
Your Lordship, only one post was there.
So if
That-
there is one post, will you recommend the person at serial number 1 and then say there are no other vacancies?
No, we
Or
considered,
you consider all of them together?
we considered, that is what. We have considered now only on the ground of, he is raising the plea that the ground of economic criteria. He says that the private respondent is better well off placed than me, the petitioner. And that is why on last
You are
occasion,
appearing for whom?
for the DLC.
Let us see.
On last occasion, your Lordship directed us to produce that particular statement of case comparative cases as to on what basis the petitioner was selected, petitioner was rejected and the private respondent was selected. If your Lordship peruses the serial number 2, tick mark red is the private respondent and the second tick mark at the bottom is the petitioner. The private respondent, he got more marks and the evaluation criteria was also asked for, and we have that also. On what basis it was calculated. And he got more marks, the private respondent.
No, tick mark is whose tick mark? Okay.
Private respondent.
Yes.
Gul Nahar. Gul Nahar become.
Yes, you show it to Mr. Soroni.
Let them file an affidavit, my lord. so that I
You
can-
file an affidavit.
Very
Bring it on
Because
record.
my lord, the ground, my lord, no doubt she may be better candidate. I must know, my lord, if she's a better candidate, she's more required service than me, my lord.
No, you are better financially.
No, my lord. I
That
have
is what is reflected.
only 3 quotas have done, nothing, my lord. Mom and me, myself, my
That is
lord.
what is reflected. We are going by what is.
They have in
is-
the Rohingya town, I am in the village, my lord. Their her land value is more valuable than behind the Rohingya station, my lord. Let them file an affidavit because I have to compare also, but because they have randomly selected
All
her
right.
without any reason.
Heard learned counsel for the parties. Mr. Soronia for the petitioner and Mr. Bora
D Bora.
for respondent,
Respond numbers 4 and 5.
4 and 5.
No, 3, 4, your Lordship. Four.
Mr. Upadhyay for
1, 2, 3.
1, 3, and
1, 2, 3.
1, 2, 3, 1, 2, 3.
1, 2, 3. And
I'm for
your name, please? AU Ahmed appearing for respondent 5. The petitioner is aggrieved by the rejection of his case by the DLC for compassionate appointment in its meeting held on 3001-2014. In the case of the petitioner along with other persons were rejected on the ground of lack of vacancy. Stop. The private respondent was considered for filling up, was considered and her name was recommended for compassionate appointment or filling up of the post of peon within bracket grade 4. Stop. Mr. Bora, learned counselor representing the respondent government, has produced before the court a copy of the tabulation prepared by the department showing the financial standing of the various candidates. Stop. As per the tabulation produced before the court, it is seen that the petitioner is shown to be having a better financial standing than the respondent number 5. Stop. Mr. Bora submits that it is on these considerations that the case of the petitioner could not be recommended. Stop. Mr. Sarania submits that these information placed before the court ought to be brought on record, enabling them to file effective response if so advised. Accordingly, Mr. Bora will file necessary affidavit, bringing on record the tabulation sought to be prepared.
Well, may I bring on record one thing, my lord? Last page of my petition, my lord. In the year, they have recommended, SLC recommended 2, my lord. That also be justified, my lord. So they have only recommended 1 DLC, but SLC recommended 2. By the same notification, same, my lord, notification, both have been recommended, have been appointed. Last paragraph, my lord, last page, my lord, 2000, page 23. my lord.
Doesn't matter. Let us get the record.
Let them justify also why they have recommended 2, if there is one person has been forwarded, recommended, my lord.
Which page?
Last page, my lord, page 23, my lord. For the year 2016, my lord. They, serial number 5,
Right, Mr.
Gul Nahar
Sarania
Begum.
further submits that the grounds for rejection of the petitioner cannot be accepted in view of the information available through RTI, which shows that for the year 2016, besides the respondent number 5, another person was appointed as a Khalasi in the grade 4 for the year 2014-16 under the Rongia division within bracket irrigation. Stop. As such, the contention of the respondent authority that the case of the petitioner was rejected because of lack of vacancies is disputed. Mr. Bora will file effective response to the contentions raised.
Only problem is basically SLC is not made a.
Well, I'll make party, madam.
That is why he has
I'll
to
make party,
complete the SLC.
Why is SLC required to be made a
Because I need
party?
to get this information from SLC now.
There is no
That's the one.
law which says that they'll have to be made a party. You require instructions. If they don't give you instructions, you inform us. Why should they be made a party?
Because.
You want instructions from the office of the chief secretary. Get it. You produce a copy of this order if required.
A copy of the order maybe.
Get it from the web. Why do you want a free service?
I love it.
Yes.
Please, Lordships, in this case, the other side has filed the affidavit, their affidavit, and I need to file the reply, Lordship. 2 weeks time may be granted, Lordship.
Learned counsel for the petitioner submits that you'd like to file a reply
To their affidavit.
affidavit to the affidavit in opposition filed by the petitioner, by the respondent. He prays for 2 weeks' time. Matter adjourned as a matter prayer allowed, matter be listed after 2 weeks.
All right.
Yes.
May it please your lordship. Lord, my lord, my senior is suffering from eye flow. Kindly adjourn this matter.
Who is your senior?
Aspiras. Aspiras. Mr.
Yes, what do you say?
Only want my lord, my lord, ran over me, Lordship. My lord, I requested to come, my lord, big consent saying that he is suffering. from-
Yes or no?
No, Lord, yes, Lordship.
Yes. Learned counsel appearing for the respondent submits that the arguing counsel is indisposed and therefore prays for a short date. Prayer is not objected to by the learned counsel petitioner. Accordingly, lists the matter after 2 weeks. 2 weeks.
Like.
You may please, your lordship. We want to withdraw this case.
You want to withdraw?
Yes. Because
It is
it is a
submitted by MS so-and-so learned counsel for the
first,
petitioner on instructions that the petitioner does not wish to press the writ petition any further and seeks to withdraw. Accordingly, writ petition stands dismissed on withdrawal. Mr. Bora appears for the respondent. Interim orders, if any, stands vacated. Yes.
may please, your lordship.
Yes.
Lordship, in this case, what happened, lordship, petitioner, while he was serving as a lordship, deputy manager in the Naga Electrical Division, lordship, he lodged an FIR, lordship, against one of his employee, lordship. Thereafter, after investigation, police submitted final report, lordship. And one notice was issued to me, lordship, regarding that final report, lordship, and I went to the court and lordship, filed my no objection, lordship. Thereafter, department started and one proceeding against me, lordship, for filing of no objection regarding that matter, lordship. Proceeding was going on, lordship. Thereafter, inquiry report was submitted. Charge was for neglect of duty and lordship, violation of officers' rules, lordship. Thereafter, lordship, after inquiry, lordship, report was submitted, lordship, charge was proved, lordship. Thereafter, punishment was issued against me, lordship, for lordship. They are
Let's see.
imposed, lordship, one increment, lordship, for cumulative effect, lordship.
What?
And for stoppage of one increment, lordship, with cumulative effect, lordship. And lordship, thereafter, that is an annexer 12, page 48, lordship.
Yes.
Participation, page 49, lordship, last line. It is accordingly ordered that one increment of Sri Dulal Mohanto, deputy manager, will be stopped with cumulative effect, lordship. I have challenged this order, lordship.
Any appeal?
Yes,
against that?
appeal file, lordship, appeal dismissed, lordship. Then I have challenged that order, lordship. It was
Appeal is rejected.
rejected, lordship. Against that, lordship, I have filed a writ petition before this honorable court, lordship. My main ground was that, lordship, I was imposed punishment under regulation 10(1)(2), lordship. But regulation 10(1)(2), lordship, there is no punishment of stoppage of increment, lordship, with cumulative effect, lordship. So this honorable court, lordship, dispose of that writ petition, lordship. Lordship, kindly see page 80 of the judgment passed by this honorable court, lordship, page 80, paragraph 20, lordship.
Yes.
May I read paragraph 20? It may also be noticed herein that the penalties that can be imposed upon the officer of the establishment are provided in regulation 10(2)(a), wherein amongst the various types of penalties that can be imposed, stoppage of increment for a specified period has been provided at regulation 10(2)(a)(3). However, in the case of the petitioner, the penalty imposed upon him was no doubt stoppage of one increment, but the same has been made with cumulative effect. While examining the penalty imposed upon the petitioner, it may not be out of the place to notice the fact that the respondent number 4, although proceeded with a separate inquiry proceeding, altogether was imposed with the penalty of reduction of pay by one increment in the existing time scale. The said penalty was subsequently restricted or made effective for a period of 1 year only. Therefore, it can be seen that the respondent authorities are aware of the fact that if the penalty of increment is to be withheld, the duration of the penalty is to be specified in terms of the regulation aforementioned. So that was the observation, lordship, and I was directed to file a fresh appeal, lordship, before the authority. Accordingly, I preferred an appeal, lordship, and that was, lordship, rejected, page 23, annexer 23, page 84, lordship.
Page 80.
84, lordship. Second paragraph, after threadbare discussion, the board observed that all required formalities had complied with while imposing the penalty by the concerned authority and disposing the appeal petition of so-and-so by the board of directors.
Where is the punishment again?
Lordship, regulation.
Punishment
Punishment, lordship, that is
48.
48, page 48, lordship, annexer 12.
Where, do you have a copy of the rules?
Yes, Lordship.
My lord, without troubling too much, my lord, I have to concede. Because, my lord, normally, my lord, increments are withheld for a specified period, but this person, it seems cumulative, it goes on. And in the rules I have also perused, my lord, there is no such provision.
In the meantime, Lordship, petitioner retired, Lordship. Otherwise, it will affect his terminal benefit. In fact, the main accused, Lordship, who was the accused of the that criminal case, Lordship. Initially, he was Lordship also stoppage of increment, Lordship, for times case. Where Lordship, thereafter his punishment was Lordship modified, Lordship. And with a specified period. I have annexed that order also, Lordship.
Specified period.
Yes, specified period.
Yes, so
Yes, my lord, so once the word cumulative comes in, it is not specified, it goes on and on.
Yes.
My lord, to be very frank, my lord, I have to concede to the and have to admit, my lord, this is wrong. And there is no provision also.
if you concede, what happens now?
My lord, it will have a, now it will have an effect on his pension also, because that increment had been stopped.
You are conceding to what effect?
I am considering to the effect that that quantum of punishment, which was, it
Has
was
to be
dehoused the rules.
specified.
It was dehoused the rules.
So you want a remand before the authorities, or you want this?
Set aside the order, Lordship.
It's up to your lordship, but perhaps very, same. If this is the attitude, my lord, if it will again come,
All right, we'll pass orders.
my lord,
Obliged.
always. My lord.
Disposed. None appears. None appears for the petitioner and called on. Stop. On 10/3/2022 also, when the matter was called up, none had appeared for the petitioner. Accordingly dismissed for non-prosecution. Interim orders, if any, stands vacated. Mr. Rava appears for
BTC, my lord.
BTC, Mr. Hendik for
For 1 and 3, lord.
1 and 3, Mr. Dhor for WBT.
Yes.
Please, your lordship. In item number 20, your lordship, I have filed an internet application packeting.
You have
the
filed
stay-
a,
I have already filed, your lordship, IA civil for packeting the stay order. It is not in record, your lordship. It is a matter of.
IA. You have
IA.
filed an IA.
Already filed, your lordship. A number is 2680/23.
It is submitted by the learned counsel for the respondent that
Respondent
an
side.
IA has been filed seeking vacation of the interim order dated
Interim order dated, your lordship, 28/6.
28/6/2023. However, that IA is not listed today.
Friday, your lordship.
Registry is directed to connect the IA stated to have been filed by the respondent number
7.
7 and connect it to the present writ petition and list it before the court.
Order may kindly be extended, interim order. 20th.
Madam, I come up Friday, your lordship.
It should be extended.
Interim order was not extended last time. 8/8, it was not extended.
Because these cases were listed along with a bunch of restrictions, maybe.
I like it. It's very listed, your lordship.
What interim order was granted?
Lawsuit taking into account, the lawsuit matter was hard lawsuit at like taking into account the above and more particular as the respondent number 7 has not filed any affidavit in spite of the fact that the writ petition was filed in the year 2019.
All right, list on,
In the interest of justice, states the selection of an appointment of the respondent number 7.
um, 18. List on 18. Interim order passed on 28/6/2023. Will continue till the next date.
In next case, item 21, in this case, I have filed it with opposition. It is also not record.
Let it come up along with.
Lawsuit in item number 21, also I filed an interlocutory application for extension of the interim order. It has been listed as item number
Interim order passed in item number 21,
21, lawsuit.
also extended till
71
18.
lawsuit supplementary order.
Till 18. It is extended till 18.
I have filed an interlocutory application.
Where is that IA?
Item number 71. Lawsuit, the first order was at page 9, lawsuit.
Which order you were asking for extension?
Lawsuit order dated 4/9/2019.
4/9/2019, you are asking for a stay in 23?
Lawsuit, subsequently
extension?
also, lawsuit, I have annexed all the orders, lawsuit. Only on. two
You are
occasions,
asking for extension of which interim order?
Lawsuit, dated 4/9/2019, it was subsequently extended, lawsuit.
That is what we are asking you. Where is it, the last extension?
Last extension, lawsuit, I have, at page 28/6/2023, lawsuit, page 25,
20,
page 25, last page,
25.
yes, page 25 of the IL, lawsuit. On 28/6/2023.
The interim order was granted on 4/9. When was the interim order granted? 4/9. 2019.
19. Interim order was earlier.
In the IA heard so and so, counsel for the petitioner. This is an IA filed with the petitioner seeking extension of interim order granted earlier by this court by the order dated 4/9/2019 passed in WPC 6447 of 2019. Stop this 8 order was subsequently extended on various dates, and the last extension was on 28/6/2023. Since the matter was not listed on the date fixed, prayer for extension of interim order has been made. Have you served copies?
Yes, sir.
Learned counsel, so and so appears for the respondents. it is submitted that the matter requires a hearing and attempt will be made to dispose of the matter at the admission stage. Connected matter is also listed on 18. Accordingly, prayer made in the IA is allowed. Interim order passed on so-and-so date is extended till 18/9/2022. IA stands disposed. Writ petition 6447 to be listed along with 5433/2019. Not on 18, let it be on 19th. 19 for admission.
Obliged. Betting up.
As per
My lord, pursuant to the order dated 21/8/23, we are filing an IA, my lord. We have sent it for vetting to the LR, my lord. So we need further 1 week time. In 1 week, we'll file it.
For what purpose? Is that creation of post?
Yes, my lord.
Why are you filing the I?
seeking permission for superannuation creation.
Why are you filing an IA? Or you're mixing up your instructions?
Upon instructions, my lord. No, my lord, it's reflected in the last order, my lord. Last order, my lord.
Uh,
Mr. Nat seeks liberty of this court to file a proper application. That
For
is
what?
what my friend said. Just inform me that it has been sent to the judicial department, my lord, for vetting. So in next 2-3 days, we are getting it back.
Call Mr. Nath, we'll find out at 2 o'clock. You call Mr. Nath, let us understand what IA. Ask him to be present at 2.
Right.
We'll take it up at 2 o'clock.
Maybe please your lordship, my lord. My lord, I am on behalf of B Bhia. She is not present today. She is not feeling well. Therefore, the matter may be adjourned for today and may be listed after 1 week.
It is submitted by Mr. So-and-so, learned counsel preparing for the petitioner that the arguing counsel is indisposed. Therefore, seeks adjournment for a week. Mr. P.K. Roy, learned senior counsel representing FCI, does not object to the prayer made. List after 1 week.
Obligement.
Yes.
In this case, my lord. Three repetitions are there, my lord. The first, my lord, is 9573, my lord. We filed this petition because of that, my lord, in 3/2/2016, my lord. They filed an affidavit, my lord, stating that our service was terminated in the year of 1992, my lord. That was now challenged, my lord. If honorable court permit me, my lord, in case number, my lord, there is an order, my lord. In this case, my lord, there is an order, my lord. The matter is listed along with, my lord, 3288/2016. And 3288, my lord, there's an order, my lord, is by order dated 8/2/2023, my lord. 8/2/2023, my lord. May I read, my lord? 8/2. My lord, there is a two cases as there, my lord. WPC law 3329/2016 along with connected, my lord, matters, my lord.
There's an order, my lord. Please, by order dated 8/2/2023, my lord. May I read, my lord?
Yes.
8/2/2023.
In 3329.
Yes, my lord. My lord.
Yes, tell me.
3/320. There is order 8/2/2023, my lord.
Yes, please read.
In pursuant to the order dated 23/1/2023, the Learned Council appearing on behalf of Elementary Education Department had placed the certain so-called notice, which were issued to the various petitioner as well as replies so submitted by the petitioner and the termination order. However, it is relevant to note that from the instruction, it reveals that petition number 1 to 15 in 3/2/2016 were served the termination notice as per letter number so and so dated 12/5/1992. This court has also perused the said notice, says an order of the termination. It is, however, not apparent from the said as to whether the service of the termination orders were meted out to the petitioner in the instance case. This court further taking into account the direction passed in order dated 27/4/2012 passed in so and so, direct the respondent elementary department to file affidavit in terms with the instructions so produced today, and said affidavit shall also indicate as to when and how each of the petitioner were served the termination order, my lord. And therefore, my lord, my learned friend filed an affidavit in opposition, my lord, affidavit, and they did not state it anywhere when and how they served the termination order, my lord. And so they file an affidavit, and I also file reply, my lord.
Hmm.
My page affidavit file on my lord 5/4/2023, my lord. My learned friend, my lord.
Yes, so what is your prayer today?
My prayer is that, my lord, 3 cases are there, my lord. There must be some hearing is required, my lord. So many judgments I also brought.
Hmm.
Before, my lord, my fixed date for hearing day, my lord. And
You
another
you decide
conflict also
which
there, my
date
lord.
is suitable for you.
Yes, my lord. Any hearing day, my lord, your lordship, my lord. There's a puja vacation is also there, my lord. And
Puja
2nd of-
vacation.
it's coming,
It's
my lord.
still many weeks away.
And then before that, my lord, any, my lord.
Yes,
28th, my lord.
Goswami,
No. 28th. Right?
510,
5/10.
510.
Yes.
Matter be listed for hearing.
Already rule was issued, my lord, in this case.
Huh?
In this case, was already rule was issued.
Then why is it listed for admission?
No, rule was issued, my lord.
Rule issued in which matter?
In our first case, my lord.
3329.
My lord, 2023, my lord. Yes, my lord, that's 9/5/2019. my lord. By order date 3/1/2020, issue rule returnable 28/1/2020. Maybe admission.
In item 9573. Writ petition 9573 2019. Rule in the matter was issued on 3/1/20. Accordingly, matters be listed for hearing. Stop. Learned councils for the parties are agreed that matter be listed for hearing on 5th of October.
March.
May I please your lordship? My lord, the last occasion, my lord, 28/1 as per order dated 22.
20. May I please, my lord? My lord, the conducting council, my lord, beach order is suffering from conjunctivitis, my lord. My lord, may I adjourn for the
For whom?
beach order, APDCL, my lord.
For? For
My lord, APDCL.
appearing for respondent APDCL.
Yes, my lord.
It is submitted by learned
My lord,
council,
as per order.
Mr. So-and-so, that the conducting council appearing for APDCL is indisposed and he prays for 2 weeks. Prays for an adjournment for 2 weeks. Yes,
My lord, as per order dated 28/1/22, my lord. They have supposed to file affidavit, my lord, another related matter, but I have not received that affidavit, my lord.
Moreover, my lord, already similar weights of writ petition, my lord, already disposed of, my lord.
Any order? Any order?
Yes, my lord. Matter may be disposed of in the line of.
You show it to him. If he agrees, we dispose it.
Not at my instance, my lord, at least for today, my lord.
Huh?
Only
Not at my instance, my lord.
All right, Friday, let it be on Friday. Friday.
No, next Friday, my lord, not this Friday.
You have to just see whether this matter is covered or not. You give us a copy, put it in this file, matter be listed on Friday. As it is submitted by the learned counsel for the petitioner, that similar writ petitions have already been disposed of. Learned counsel appearing for the respondent will peruse the order and apprise the court accordingly on Friday, 15th. Copy of the order be.
I am always, my lord.
Yes.
May please your lordship. My lord, the petitioner people lordship, they are working as a grateful and masterful basis.
My lord,
Employment, my lord.
I am for respondent number 7, 8, 9, 10. For 7, 8, 9, we have filed affidavit in opposition. For 10, the newly implemented respondent, we have filed Wakalatnama, but yet to file affidavit. So this matter may be taken after 2 weeks.
Who is 7, 8, 9, 10?
My lord, they are also similarly working persons like the petitioners, but they are given the benefit of notification 2019 and remuneration of rupees 15,000, and we are not given, my lord.
You
That is
are working as what? Pankha
my lord,
pullers.
initially were employed as a pankha puller. My lord, in the remote.
Are there any pankhas required to be pulled, available
My lord,
today?
They were wage earners.
wage earners, wage earners. Master basis they are
There
working.
is no basis, my lord.
My lord,
And nowadays it is not available.
my lord.
In particular, we are everywhere. After that, my lord, they are not.
No, my lord.
2017, they are not.
No, my lord,
They are not required for the winter months, only
My
for
lord,
summers.
Subsequently, they are engaged as a chain man, my lord, under the
Chain man.
chain man.
Yes.
And
Which notification you are relying on?
my lord, we are relying on the notification that has been annexed in their affidavit, my lord. Lordship will find in the notification at an annexer 10 at page 76 of the affidavit, my lord. Affidavit filed by the respondent number 7 and 8. By that notification, my lord, with effect from
They have to stand their case on their own feet. We are trying to let them show, my lord, that from after 2017, they have been working.
my lord, there are sufficient documents that goes to show that the respondent number 7, 8, and 9 are working similarly. There are so many communications, but exclusively, my lord, they are considered for the benefit of this notification. We are not. My lord. Well, their document says that we are working together because we have not succumbed to their demand of extraneous consideration. That is the reason, my lord, giving a discriminatory treatment to us.
Now, these are private respondents.
My lord, private respondent.
So why this, why the benefit is not extended to them?
They are not in service, my lord.
Not in
My
service,
lord.
yes.
My lord.
From
And
2017, my lord,
the respondent was 7 and 8, they were also not given regular appointment. They are also masterful workers, time to time engagement. We are also given same type of engagement, but why?
You are asking for what, arrears or
My lord,
current?
we are asking that we may be given a benefit as extended by this notification that my lord dated 3rd October 2019.
So are you in employment or not?
My lord, we are still working, my lord. Still
let
working,
them, let
but
them
on
show a
master
document,
basis.
my lord, that they are working. Let them show in appointment, my lord. At least
My
an
lord,
engagement.
before giving the benefit of these documents to these three persons, let them show also, my lord, that they were working all along, without any fail, without any break. Can they show, my lord? No, my lord. They cannot show, my lord. Their documents shows that we are also along with the, respondent number 7 and 8.
No, assuming
My lord.
that there is no document, these private respondents are unauthorized, will it give you a right?
My lord, master law workers, my lord. My lord.
We may
we are-
direct the government to stop payment of wages to the unauthorized people, including private respondents. That's a
lord.
different option.
No, my lord.
But they are being given a benefit unduly. Can the same benefit be
No, my
extended
lord.
to you?
No, my lord. We are not saying that they are given benefit unduly.
Ah.
They are also deserving person. They have got, we have not got.
No, they are deserving because now you want the same benefit.
My lord, yes, my lord.
Ah.
My lord, we have want the same
But the
benefit.
question is that,
My lord.
that to come to a finding whether they are deserving or
My
not,
lord.
you'll have to have the official
My lord,
documents.
it is my writ petition. They have started, my lord, before my opening, my lord. Kindly have a look at the documents, my lord, we have.
Yes, yes.
My lord. But annexer at 1 page 14. My lord, 14. This is the acquittance role of the master roll workers. Fixed pay at that time, my lord, 1994. Naib Ali, my lord, he is the respondent number 9. He has got the Ranjit Kolita is the petition number 1. He has not been given. Hori, my lord, the name is something, my lord, Horidev, my lord, Das, my lord. He is also getting benefit. Respondent number 7. My lord, Tajuddin, my lord, is the my lord, represent, my lord, father of the petition number 4. He has also worked, my lord. Then, my lord, the other documents, lordship will find. Annexer 16. This is the acquittance rule of 1995 to 1995.
No, now you are claiming benefit for which period?
My lord, my claim is that we also may be given the benefit of the notification. They may be given the wages fixed by this notification. That is our limited requirement. If they are working, my
So your current engagement, for the current engagement, you show us any document.
my lord. My lord, the last, my lord, they were paid, my lord, by allotting fund. My lord, the annexure 9 may kindly be looked at, my lord. Annexure 9 page 32 and 33. The required budget were provided on asking by the
Let us
circular-
come to page number 26, for instance.
My lord.
Now in 26,
Yes, my lord. At that time, they were given as a salary, lump sum, my lord, salary 370 per month.
this is for
And-
which year?
My lord, this is of this is of
Huh?
1991, my lord,
91.
91. And here, my lord, the respondent number 9, Naib Ali, then my lord, the petition number 1, Ranjit Kolita.
No, now for the present, where are your documents?
My lord, present document, my lord, my lord, she may kindly have a look at, my lord, the page 30. This is another project requirement communication. 2009. Naib Ali is at serial number 1. Horidas, respondent number 7. Ranjit Das, petition number 1. Then Tajuddin, the father of the petition number 4. Somir Ali, petition number 3.
Kindly see the letters.
Say,
They are engaged as a same man, not as a puller.
Yes, my lord. Initially, they were engaged as a Pankha puller. Subsequently, they were engaged as a same.
How can they claim the 2005, my lord? They were engaged as a 2009, 2008 only.
My lord,
Newly engaged.
there is a documents of showing, my lord, engagement of 2017 and 18, my lord, page 33.
On that day, my lord, in a.
33, where are your names?
My lord, yes, my lord.
33.
33, my lord, Mainul Haq is the petition number 2. Then Ranjit Das, petition number 1.
Ranjit Das is not in the petition.
He is Ranjit Kolita.
My lord, the name is wrongly written here. My lord. Name is wrongly written, my lord. It should be Ranjit Kolita, but.
Now
they
you
have-
see, there are two Ranjit Das.
My lord,
One is at serial.
my lord, they have wrongly mentioned the name, my lord. That is the problem, my lord. There are other documents also,
Where are the other documents? That's what we are asking you.
my lord. Annexer at page 37 and 47. Annexer 11, my lord. Here, the respondent number 7 at respondent number
37 or 36,
page
35,
37, my lord.
37,
37.
37.
37, my lord, Naib Ali, he is the respondent number 9, and the Ranjit
No,
Kolita,
No, 37 of your writ petition.
writ petition. My lord. Ranjit Kolita at serial
Your
number
writ
2,
petition, this page number 33,
The amended petition.
amended writ petition. My lord.
is another amended writ petition.
Yes, my lord.
Yes, we're looking into the amended.
Annexer 11, my lord.
In your amended writ petition,
Yes, my lord.
yes, 37,
Yes.
yes,
Annexer 11,
yes.
here, my lord, the
Ranjit
Circuit
Kolita.
Deputy Commissioner required fund for them, my lord, 6 persons. Naib Ali is the respondent number 9, Ranjit Kolita petition number 1, Haridas, my lord, he is also one of the respondent. Tajuddin is the father of the respondent number 4. Then, my lord, Somir Ali, petition number 3, Akas Ali is also one of the respondent. My lord. So they are all together, my lord.
My lord, this is of
They are all
2005.
together.
Hmm?
This is of 2005, my lord.
Yes.
Couple are subsequently engaged as a same man.
Subsequently,
My lord, they cannot show that the prior to this notification, my lord, they cannot show any
Since
document
1st
that
January
the
2008,
bill,
they
my
have
lord,
engaged the same
my lord, my lord, wages has been called, required separately, excluding our name, my lord. They are all along, my lord, in together, my lord, requiring fund. And now they are excluded us, my lord, very illegally, my lord. Nobody is in a regular employment, my lord. We are working temporarily, sometimes as a chairman, sometimes as a panka puller. But now, my lord, if
No, but 37 is of a paper document of 2005.
maybe, my lord, but 2000, my lord, 17
Now
also,
37 is for what? Is
my lord, here, my lord, the note, with reference to subject cited above, I am to state that the circle officer Bagbor Revenue Circle, by his letter cited under reference, has informed that 6 persons have been engaged by him to pull the pankhas with effect from 2/5/2005 in the room of the Lat Mandal, as there is no electric fan. The name of the 6 persons are detailed as follows. The above proposal submitted by the Circle Office Bagbor Revenue Circle in respect of engagement of Pankha puller in his office is genuine and sent for necessary action. My lord, well,
now government, this is a document where at least 2 persons are shown. Petitioner 1 and 3, page number 37.
My lord, this is a letter communication of 22/6/2005.
Correct.
Every year, my lord, allocation. My lord will just take my affidavit, my lord, filed by the respondent number 4, my lord. In page number 40, para 4. Respondent number 4, my lord. Respondent number 4, my lord.
Yes,
The ADCS filed this on behalf of the Deputy Commissioner, my lord, in para 4, page number 40,
para 4.
page number 40, my lord.
Yes,
I will just read, my lord. That with regard to the statement made in paragraph 2 of the petition, the deponent begs to state that Nayab Ali, Ranjit Kalita, Biren Chandra Das, Haridas, Mohammad Salim, Tajuddin Ahmed, Abdul Ali, Nupen Bayan, Akash Ali, and Mayur Haq were working on a fixed pay in the office of the block development officer, Mandia Development Block and Circle Office, Bagbor Revenue Circle, Mandia. As reported by the Circle Officer, Bagbor Revenue Circle, Mandia, from the document submitted by by Ranjit Kulta and others before this court, it is known that they are working as wage earners as chainmen till 30/6/2017. But after that, they are not present in the office of the Bagbor Revenue Circle. Sri Haridas, Nayab Ali, and Akash Ali are working till date. Accordingly, a letter has been communicated to the DL, that is, my lord, DLR, Guwahati, by the Circle Officer Bagbor Revenue Circle regarding payment of revised pay scale for casual fixed pay employees in favor of Haridas, Nayab Ali, and Akash Ali. That is the private respondents, my lord. By letter number such and such on 29/10/21, showing engagement of them as Pankhapulat since 1995. Subsequently, the budget allocation of 3,24,000 has been released by the additional Director of Land Records, such and such, for financial year 21-22 at the rate of 9,000 per month for payment of wages in favor of Haridas. This is the private respondents, my lord. So, my lord, my affidavit said that from 2017, they are in the office, they are not working.
why are they not working? 2017 till 2017, they were engaged. Subsequently, they're not working. Why? Retired, incapable, they don't want to work. What is the reason?
That is not
It
very
is-
clear from the affidavit,
that's
my lord,
right.
but they are not in the office.
They're not in the office, that is
That's
their
what-
claim. They're not in the office, so is it how are they engaged?
No.
Till 30/6/2017 means from which date it is not given, we'll assume it is from 2005 or 8 or whatever date you say. They were working. Now, if they're wage earners and if they're required to be retained, there has to be communications asking for retention,
Yes,
asking for budget.
budget. From 2017, my lord, they are not working. That is why
They are not working is a decision taken by whom? By them or by the authorities?
maybe my lord also did not renew their thing.
So,
If they would have had some documents, my lord, to show that they are in service.
let you show us the documents with effect from up to 2017. Show us how they have been retained.
My lord.
Your affidavit says they were working till 3006. You show us in what manner they were retained. If it is a case that they are required on a need basis, there has
They are-
to be some proposal.
Wage earners, my lord.
But
they have been engaged or they are not, to come.
supposing they refuse to work,
Lord,
it is possible. So that information is necessary.
And document only see the petition number 4.
Hmm?
Petition number 4, okay, only see the. His age and there is nothing has been mentioned to the when he was working, from which date he was in the service, Lordship. Nothing.
So who can get it? Mr. Hendy,
Lordship, my learned friend can.
Mr. Dhor,
My lord.
you procure the relevant documents with regard to how their services were retained up to 36/2017. Heard learned counsels for the parties. The claim of the petitioner is a prayer for grant of the benefit of which notification?
My lord, that is annex 10 to the affidavit filed by the,
Page number,
my lord, is 70. My lord, it is 72, my lord. Sorry, my lord. It is 76, my lord. Annexure 10.
benefit of the notification / orders passed by the Finance Department by the order dated order number so and so dated 3rd of October 2019, whereby which was issued pursuant to the directions of this court passed in the order dated 8th of June 2017 in WA 45 of 2014, State of Assam versus Upendas and others. Stop. The petitioners are aggrieved that these benefits are not given to the petitioners, whereas the same benefits have been offered to the private respondents. Stop. Mr. Upadhyay, Mr. Dhor, learned counsel appearing for the respondent so and so, and Mr. Hendik, learned counsel appearing for the government, submits that the petitioners cannot make a claim as they are no longer in service. Stop. Mr. Dhor has referred to the affidavit filed by the respondent number 4, who's the Deputy Commissioner, Borpeta. Stop. In para 4, there's a statement that the petitioners were working as wage earner, within bracket chainman, till 3006-2017. But after that, they are not present in the office of Bagbor Revenue Circle, Mondia. Stop. Whereas the private respondents number 7, number 8, and number 9 are stated to be still working till date. Stop. And accordingly, the private respondents 7, 8, 9 have a proposal has been sent for revised scale of pay with respect of private respondents 7, 8, and 9. Stop. Learned counsel for the petitioner submits that the petitioner and the private respondents were all engaged initially at Pankha Pullers on various dates since 1995 onwards. Stop. As such, the benefit offered to the private respondents ought to have been granted to the petitioners also. Stop. On perusal of the affidavit filed by the Deputy Commissioner, it is seen that there is a categorical averment that the petitioners were working as wage earners till 3006-2017. But after that, they are not present in the office of the Bagbor Revenue Circle, Mondia. Stop. However, no such official documents or records have been enclosed with the affidavit in support of these averments made. Stop. Mr. Dhor is directed to obtain the necessary relevant documents in support of these statements made, that to show as to how the petitioner as well as the other private respondents were engaged in service, and the nature of duties and payment of salary or wages, if any. Stop. These instructions will be placed by the learned government advocate on the next date fixed. Stop. Meanwhile, the respective parties may change their pleadings in the meantime. List again on. When will you get it?
After 2 weeks, my lord.
Date may be fixed, my lord.
4th October.
Deeply obliged, my lord.
In this case, the petitioner before Lordship was initially appointed as junior accounts assistant on 25/6/1986. Thereafter, my lord, he was promoted to the post of senior accounts assistant, my lord, on 27/1991. And his promotion was due in the year 2014. And his position in the gradation list was 5. But the persons at gradation list, serial number 6 and 8 were promoted, my lord, by order dated 30/12/2014. Now, my lord, of late, my lord, he was promoted to the post of accountant, my lord, on 30/9/2020. And my lord, in February 2022, he has also retired from his service. Now, only thing, my lord, if the repetition is allowed, my lord, will get the notional benefits. The case of the respondent is that, my lord, they did not consider my case for promotion along with my juniors because I wrote a letter foregoing my promotion. That is the case of the respondents. But, my lord, I wrote that letter not to promote me outside DQ because the education session was of my daughters were going on and a post of accountant was lying vacant at DQ. My case could have been promoted, my lord, considered against that post, but they did not consider my case at all on the basis of that letter.
You are an employee, you
Yes, but that.
you are entitled to be, depending on the exigency of service, you'll be
Yes,
posted
that-
wherever.
that I admit, my lord. Only thing, my lord, the education session of my daughters were going on.
Maybe,
That is why I wrote that
but-
letter.
But even before you were considered, you had given a caveat saying you'll not be posted outside.
That was it. Very happy.
Yes, what do you say?
Your lordship, my first objection is with regards to delay. He is claiming promotion from the year 2014. He has filed his writ petition in the year 2021.
If you have denied him his promotion, it is a continuing.
No, your lordship, because he was promoted in 2020. Secondly, he has suppressed some material facts. We have stated those facts in our affidavit of opposition.
What are these? What are these?
First is basically he has foregone his promotion and we have annexed that at page number 8, annexure 1,
Page number 8.
annexure 2, Roman 2.
What does it say?
With reference to the subject cited above, I have the honor to state that at present I am not in a position to move on promotion as accountant either to Bokajan sub-treasury or Hamren sub-treasury owing to some personal affairs. I therefore have forgone my promotion which is becoming due to me and this is for favor of your kind information necessary action.
This
Your
is
lord-
clear. What else is there?
And his case was
He was
considered
in
also.
the position to move out of DQ.
No.
29/12/2014.
These are, you read whatever is written here. You have forgone your promotion.
Yes. And
Then
But, my lord, offer was never made.
no,
It is letter, my lord. My lord,
your lordship will
consider
go to page
foregoing the
number 15
promotion.
also. Annexure 6, page number 15, the minutes of the selection committee meeting. And the relevant portion is at page number 16. Second paragraph, since Srimati N. Raskwa, that particular paragraph, since Srimati N. Raskwa, Sri Nirmal Rongpi, the petitioner, Haren Sakyan so and so, submitted application to forego their promotion to the post of accountant. The board has selected Sri Moloy Kumar Dhar and Srimati Hemanjali Hendik for promotion to the existing vacant post of accountant of Hamlin sub-treasury and the resultant account vacancy post of accountant which occurred due to promotion of accountant of depot treasury to the post of superintendent on the basis of seniority cum merit considering the eligibility of senior administrative assistant, namely Sri Molay Kumar Dhar, Srimati Hemanjali Handikoy, and Srimati Hadni Terongbi under the zone of consideration. So his case was considered. He just forgot, and your lordship may note the date also. This ministerial meeting, this selection board meeting was held on 29/12/2014, and he submitted his application on the same day, 29/12. It was considered. This fact was never mentioned in the writ petition. He kept silent. Not even a whisper. He says that he was surprised to see.
Oh, same day,
Same
same day. So would you like to withdraw or we proceed? On withdrawal, we don't need to write anything. It is for you. Mr. Ait Soikiel, and counsel for the petition, submits that on instructions that should we record it that pursuant to the filing of the affidavit,
No, my lord, that will not be recorded.
Because we have
Only I am withdrawing, my lord.
submits on instructions that he would not like to press the writ petition any further and seeks to withdraw. Writ petition accordingly stands dismissed on withdrawal. Mr. Bora and Mr. Gogoi, you appear?
Yes, what a final.
For the
I appear for respondent number 3.
Respondents,
1 and 2 have been very much.
1 and 2 Gogoi, 3 for Mr. Bora. Writ petition stands dismissed on withdrawal. Interim order, if any, stands vacated.
In fact, my lord, about that letter, my lord, I was also never informed by the client about that letter of 29/12.
So you should have allowed it to be dismissed.
I was never informed by my client. Since he has retired from his service, my lord, I'm not taking any first thing from this court, my lord.
It's a good thing he has not been promoted.
He has been born
Applies, my
subsequent
lord.
22. Lordship, affidavits for both the writ petitions have been prepared. They have been sent for waiting. So Lordship may kindly allow some more time to file the same.
On who, which department, for which department?
Lordship is BCPL, Brahmaputra Crackers and Polymers Limited.
Yes, madam.
Lordship, only a short date may be fixed, Lordship, because this matter has been getting delayed, Lordship. because
Lordship
of
may
the
have it
affidavit,
anytime
Lordship.
next, on 26 perhaps.
I'm appearing in item
You
number
first file
30.
your affidavit before you fix the date.
Lordship.
You get your affidavits on record.
Lordship.
You are Mr.
S. Mitra.
Mr. S. Mitra, learned counsel, appearing for the respondents 3, 4, 5.
Respondent number 3, 4, 5, 6.
Submits.
2 to 6.
There's no 6.
Lordship in 673122, there are two matters.
I'm appearing on item number 32 only, Lordship.
Then who's for the other matter?
Lordship.
Lordship, even on the last day, there was no one appearing for the petitioner.
Item 3, item number 31. Sorry, 31. You are appearing in?
32, Lordship.
32.
371.
In item 31, none appears for the petitioner. Mr. H. Mitra appears for respondents
I'm for
3, 4, 5. Mr. Roy for
Respondent 1,
respondent number 1.
Union of India.
I am 32.
And who's for 30? Who's for respondent 2? Secretary. You will appear. Mr. Roy for 1 and 2. It is submitted by Mr. Mitra that the affidavits are likely to be filed within a very short date. Therefore, we praise for further 2 weeks' time. Insofar as item 32 is concerned, MS N. Nirola appears for as a petitioner, Mr. S. Mitra appearing for respondents
2 to 6.
2 to 6. Mr. MS S. B. Sharma for 1 and 2. 1. Respondent 1. Same prayer, affidavits to be filed. Further 2 weeks'
Obliged,
time
Lord.
granted.
Obliged.
Lordship, after going through the affidavit in opposition from the respondent authorities, in this matter, we have sought the instructions and we have decided to withdraw it. The
Miss-
fact, because of the fact that during the time when this petition was filed.
Whatever you want to withdraw,
Yes.
you don't need your reason.
Right.
Mr.
WRD.
The learned counsel for the petitioner on instruction submits that the petitioner does not wish to press the writ petition any further. Accordingly, the same is dismissed on withdrawal. Interim order, if any, stands vacated. Who's appearing for the other side?
CKS Borua.
Mr. CKS Sorwa appears for the respondents. Dismissed.
Okay.
Also, the petitioner also, he was working as the joint director of secondary education department, and he sought promotion as additional director. And Lordship, as per my notes, Lordship, a selection committee was held. Lordship, may kindly see page 21. Page, sorry, Lordship, minutes of the meeting, Lordship, page 19. His name appeared and he was the
Where is his name?
Provin Sharma, Lordship, additional director, Sri Pritam Sogia, that minutes of the meeting, the statement and biodata of ACR determining the merit cum seniority of the candidates was placed before the selection board, DPC, for its perusal. The statement of movable and after having gone for a statement of.
You are reading from page number 19.
Page number 19, Lordship,
Yes,
additional, in the category additional director,
all right.
Provin Sharma, and number 2 is Nipen Das.
Yes.
Lordship, this minutes was of 2nd January 2021.
Hmm.
And I retired from service on 31 January 2021, Lordship.
Hmm.
Because of the delay and Lordship, the APSC in this case has filed an affidavit stating that Lordship, in case an incumbent is retired in 1 year, then APSC approval is not required. Their stand has been made clear, Lord. But because of the due to delay by the education department, Lordship, my promotion was not granted. And-
You are seeking-
And during the pendency, Lordship, I have been given notional promotion as only for the benefit of pensionary benefit. Lord. That order I have on 18/9.
What else do you want?
Lordship, only for ornamental purpose, my designation will be given.
What else? You have retired?
I'm retired.
Then what further benefits do you want?
Only for the ornamental purpose, my designation will be given. Only for the ornamental purpose, Lordship,
You have been given the benefit.
only for pensionary benefit.
What else? You can't claim for back wages because you never worked.
So that
Where-
Lordship,
where is
I
that
can
letter?
write my name as additional director, I have retired.
We close it on the basis of this notification. Heard learned counsels for the parties. This writ petition is filed by the petitioner. You have been given the benefit of
Pension.
as additional director.
As any-
So it's not an ornament. It is an additional director.
But my petitioner is not satisfied. He says that designation is not given.
How can a designation be given? He is retired. He can put it on his
Lots.
residence if he wants to. Heard
Then-
learned counsels for the parties. This writ petition is filed with the petitioner aggrieved by the fact that his case for consideration for promotion to the post of additional director was not given effect to, in spite of the recommendations of the selection board / TPC held in its meeting on 21/01/2021. Stop. The petitioner was rendering his services as he was working as what? Joint director?
Joint director.
Joint Director, Higher Education Department. Stop. learned counsel for the petitioner submits that because of the delay which had occurred at the government level, his promotion, which was recommended by the DPC slash election board, was not given effect to, and petitioner in the meantime retired on, superannuated on
31/1/2021.
31/1/2021
2021. After 7 days.
after 10 days.
Yes, after 10 days.
Stop. MS Musari, you appear for
For 1 and 2, respond number 1 and 2.
respondents 1 and 2 submits. You have furnished this notification.
Lordship.
You have given this
Lordship,
notification.
Lordship.
Submits that by notification dated 18 September 2021. In view of the recommendations given to by the selection board slash DPC, and consequent and subsequent to the retirement from service on 31/1/2021 without having been promoted to the post of additional director, the petitioner retired as joint director, was however allowed notional benefit to the post of additional director in the pay band 4 or rupees so and so with grade pay of so and so with effect from the date of his retirement, which is 31/1/2021 for pension and pensionary benefits only. Stop. MS Sharma, learned counsel appearing for APSC.
Respondent number 3.
Respondent 3 submits that an APSC has already filed the affidavit stating that the
There are 8.
submits that under regulation 4D APSC limitation of function regulation 1951 for officiating promotion not likely to last for more than 1 year, it is not necessary to consult the APSC. Stop. Better having heard learned counsels for the parties. It is seen that by notification dated 18 September 2021, the benefit sought for by the petitioner has already been granted. The same is extracted below. In view of the said notification, we do not find any reason to keep the matter pending any further. Petitioner is retired. He has been given the benefits in the rank of additional director. And therefore, writ petition stands closed, taking on record the submissions made and the notification dated 18 September 2021, copy of which is retained in the case record. Writ petition disposed. Was there any interim order?
No.
Was there any interim order?
No, your lord.
Obliged.
Obliged, your lord.
Lordship, my senior is on legs at court number 12.
Who's for the petitioner? Who's for the petitioner? You are there?
Lordship, these are the few FT matters, your lordship. These are the appointments of the FT employees, your lordship. But my senior Mr. Kane Chaudhary is appearing in this matter, but he is in legs in a part-heard matter. It's a long matter is going on in court number 1, your lordship.
Otherwise, your lordship, MHA is also given, I have been informed by Mr. Parasar, who is appearing for the MHA. MHA has also accorded sanction to not to actually pursue with this particular appointment because the NRC has not yet been notified. As and when the NRC gets notified, they will be accommodated. So your lordship may close the writ petition on that basis.
No,
Lordship,
no,
in the presence of my senior, it may be from your lordship.
this
Not
was
even-
done pursuant to a process being initiated.
I agree.
Then matter will require hearing,
Yes, sir.
be listed for admission on
The first week of or second week of October, your lord. Second week of October. Maybe
second.
third week, lordship. This third week is open this time, lordship. Third week to plan. That's for the convenience of lord.
Then 10th October. List on 10th October.
Which one, lordship?
10th.
Then, lord.
Yes.
My lord, the petitioner was suspended from service for period 22/6/2012 to 39/2012, my lord. His 50% salary was paid, my lord, but 50% is remaining, my lord. On last occasion, my senior colleague sought for some time to furnish the instruction from the state government, my lord.
He's working as what?
Retired, my lord. Retired on 28 to 2019.
Retired.
Retired, my lord, for a small period, my lord, only 3 months.
He was
Executive engineer, my lord, grade 2.
he was reinstated before retirement.
Reinstated, my lord.
Now what do you want?
My lord, 50% of that salary, my lord,
During his that
during the suspension period.
yes, pay him.
Yes. My lord, in fact, division has submitted the proposal. In my understanding, my lord, the suspension period has not been regularized till yet. Lordship may direct dispose of the matter, directing the authorities, my lord, to regularize the suspension period and to pay the amount, my lord.
When was he suspended? When was he
Suspension
suspended?
order, my lord, page 15, my lord, Annexure D,
13 July 2012.
12, my lord.
Out of a criminal case.
And page 22, reinstated, my lord. 12 to 2014,
22.
page 22, my lord. Without prejudice to the departmental proceeding drawn up against so and so, the suspension order issued by number so and so dated 13/7/2012 is vacated.
What
and
has
he is
happened to the departmental proceedings?
No, proceeding is not,
facing no.
because this is out of a criminal proceeding.
I was arrested on a criminal proceeding.
So what happened to the criminal case?
Acquitted, my lord.
But that has not been annexed here.
It is
Some
not
of the
annexed, my
orders,
lord.
I heard learned counsels for the parties. This writ petition is filed by the petitioner who's aggrieved by the non-release of the subsistence allowance.
Subsistence allowance portion has been paid.
Huh?
Subsistence allowance during the suspension period that has been paid. The remaining period, remaining amount, my lord.
50% paid, my lord, 50% not paid.
Total salary here.
Okay. He is aggrieved by the non-release of the 50% of the area salaries.
During the suspension period.
Pay a claim which is stated to be payable to the petitioner during the period he was under suspension. Stop. The petitioner submits that by order dated 13th of July 2012, petitioner was working as sub-engineer grade 2 of Dhemaji. Oma WR division Dhemaji was placed under suspension with effect from 22/06/2012 until further orders pending drawal of departmental proceedings. Stop. This suspension, according to the petitioner, was this suspension order, according to the petitioner, was issued as the petitioner was arrested in connection with a criminal case. Stop. Subsequently, by order dated
PS 23, my lord, memo number 372 dated 12/2/2014.
by order dated
12/2/2014.
12/2/2014, petitioner was reinstated in service. Stop. During the period of suspension, he was paid his subsistence allowance. Stop. Subsequently, the petitioner superannuated. When did he retire?
28/2/2019.
Superannuated on 28/02/2019. Stop. By office order dated 4/6/2019, provisional pension was, sanction for provisional pension was recorded to the petitioner. Stop. The grievance of the petitioner is that his the criminal case which was filed against him and because of which he was placed under suspension, he has been acquitted by the trial court. Stop. Consequently, it is his claim that since the only ground for putting the petitioner under suspension is the pendency of a criminal case where subsequently he has been acquitted and the judgment has attained finality, the release of 50% of his salary during the period of his suspension be directed by the respondent authority. Stop. Where Mr. B. Goswami, learned additional AG appearing for the respondents, submits that
The period may be regularized by the authority immediately. Madam. The period of suspension that
the
may
period,
be regularized immediately.
there is already a proposal which is under consideration of the department for regularizing the period of suspension and thereby consequential orders for release of balance arrear of 50% will be passed by the department. Stop. Having heard learned counsels for parties, this court is of the view that this petition can be closed with a direction to the respondent authorities to expeditiously process the proposal stated to be pending before the department for regularization of the period of suspension of the petitioner. Stop. Once the period of suspension is regularized, the arrear, if any, according to the petitioner, the arrear of 50% according to the 50% of salary during the period of suspension, according to the petitioner, be released without further delay. With the above observation, the writ petition stands closed. The directions of this court be carried out within as expeditiously as possible within the outer limit of 60 days.
From the date of receipt, you will furnish.
From the date of receipt of a certified copy of this order. Petitioner will furnish a copy of the certified copy of the order before the competent authorities. Writ petition stands disposed of.
First, allow me 2 weeks time to file my affidavit, madam. After a long time, it has been. Okay, after the interim order, it may continue.
Mr. S. Bora, learned counsel GMC, phrase for 2 weeks time to file the affidavit. Mr. P.P. Bora, learned counsel for the petitioner, submits that the interim order be allowed to be continued. Accordingly, list after 2 weeks, interim order passed earlier will continue. Yes, Mr. Nath.
This item 4.
Oh, item 4, yes. Item 4.
Lordship has perused that comparative statement.
My lord,
Where is the statement?
At this.
Yes.
my lord, do we have stated our financial page 31, lord, can we kindly see?
Hmm?
Page 31. Our financial status, my lord.
No, but this is the statement of the department.
Lordship.
They found out if you dispute it,
Let them file affidavit, my lord.
filing an affidavit.
We have taken another ground also, my lord. I have stated in para 10. my lord. They have considered in grade 4 post, my lord, and grade 3 post, there is also, as per information, grade 3 posts are also available.
If your financial condition does not permit, then what is the point in passing an order? What is the basis of arriving at this total amount or GPF?
Yes, lord.
Gratuity, family pension, GPF. This is something you cannot deny. Then
I'll go through it, my lord. Let me
Private
sometime-
respondents, just his size of the family member is bigger.
it doesn't matter. Your financial condition is reflected here.
Yes, Lordship. So rightly rejected, Lordship, by the court.
Hmm?
Rightly rejected.
Yes.
My lord.
We close it.
But, my lord, may let them consider once again, my lord,
Consider what?
if the post, other posts are available, my lord. So she right from the, my lord, 2014, she's approaching before the authority, my lord. Before that, another writ petition also.
We
filed, my
cannot
lord.
direct, if you want to apply, you're within your rights to apply, but to direct them now to consider on what ground?
My lord, there is a provision also, if the post is not available in that department, there may be.
Everything I understand, but the financial condition is also one of the criteria.
Lordship.
Can you deny this?
My lord, I'll go through it, my lord. I have not seen. my
All
lord.
right, you go through it, we'll take it up on Monday.
Right.
Coming Monday.
Lordship.
Please take it on Monday, enabling the learned counsel for the petitioner to peruse the instructions furnished by Mr. Borua, learned government advocate, in respect of the financial standing of the petitioner vis-a-vis the private respondent. Matter will be listed again on Monday. 18th.
Complaint.
Person to Lordship's last order, madam.
No, I wanted to recollect why this order was passed.
Lordship.
What application were you required to file?
In fact, Lordship has directed us, Lordship may kindly come to the
The
order.
application is before the court or before the authority?
No, before the IA has to be filed because there is a order of 19/9/22, no?
19/9.
19/9/22, Lordship
Yes.
has finally directed us.
Hmm.
Paragraph 3, not. It is stated that in the above circumstances, the authorities are unable to proceed with the final pension of the petitioner, but however, as it is an admitted position that the petitioner did serve as a copyist in the office of the learned Munsif at Obhayapuri and the post of copyist is otherwise is a pensionable post. In these circumstances, as required under Rule 22 of the Assam Service Pension Rules 1969, the learned Munsif at Obhayapuri is directed to process for payment of provisional pension to the petitioner at any rate as may be determined, and the provisional pension be paid from 1/11/22 onwards. The judicial department shall also do the needful as may be required for the purpose. As regard the requirement to submit proposal for a retrospective creation of the post, the same be done by the learned Munsif as per requirement. Only to the extent of proposal for retrospective creation of post, the department has communicated that instead of instead of the proposal for retrospective creation of post, we would like to process the matter for creation of a supernumerary post. It would lessen the time as well as it would be convenient for the department. So we want to have a supernumerary post creation.
All
If
right.
Lordship allows us, without modifying this order, along with that option also,
Very well. When are you filing the application?
application I have sent, within 2 days we can file.
Let it be on Monday then.
Lordship.
Or we can have it on 20. Can you file it by
By that time, Lordship, this will come, Lordship,
20?
20.
Heart learned councils in terms of the liberty granted earlier by order dated 21/08/2023. The learned government advocates. Seeks further time to file a proper application for sending a proposal before the appropriate department in the government for creation of a supernumerary post as by earlier order passed by this court on 19/9/2022. This court had directed the respondents to submit a proposal for a retrospective creation of the post. Stop. Mr. Nath submits that within a week's time, the matter, the application will be filed. And accordingly, let the matter be listed again on 20.
20.
2009.
We have prepared the IA for modification of the order.
Whatever
Lordship.
For by which time the IA be filed.
Malad.
Stop.
Lordship.
If any such IA is filed, the registry will list the same along with the present writ petition.
Malad. Lordship.
Next.
Malad.
Yes.
Need previous development. The main question in this writ petition is whether a person who is interested in the inquiry and a person who has filed the initial inquiry, the preliminary inquiry who has furnished the initial preliminary inquiry report can be appointed as the presenting officer.
Lordship, in this case, Lordship, the petitioner has, Lordship, filed this writ petition praying for change of the presenting officer, Lordship. And on the first date, Lordship, the interim prayer was not considered. And thereafter, the disciplinary proceeding has initiated and it has come to a final conclusion, Lordship, in just in few days, Lordship, the inquiry report will be ready, Your Lordship.
You challenge the inquiry report as and when.
Kindly
Have you
peruse
participated in the inquiry?
kindly peruse the.
Have you
order.
participated in the inquiry?
Yes, we have participated, my lords. My lord, kindly peruse the order dated 23/9/2022. This court has succinctly, my lords, reproduced all the facts, my lord. And in fact, my lord would peruse the last but one, my lord, the paragraph there. my lord. However, considering the important question of law.
Yes.
However, considering the important question of law raised in the writ petition, I am of the view that the respondent should respond to the writ petition by filing their respective counter affidavit so that the matter can be finally decided at an early stage. Now, the fact remains, my lord, if this court holds that the presenting officer who has been appointed,
There is no interim order.
there's no interim. I understand. What I'm trying to place, my lord, that if this court finally holds that the presenting officer could not have been appointed as the presenting officer,
due to bias or due to the likelihood of bias, the entire disciplinary proceeding goes, my lord. That
That is a ground you can always urge when you put the disciplinary.
I had initially, my lord, taken that.
You had, but you had prayed for an interim order that was rejected.
The interim order was rejected. Nonetheless, my lord, the court had observed that it's a question of law that has to be decided. Now, if your lordship decides that
You're
the-
not you see, you're not getting the query of the court. We'll decide it. We are not saying we are shucking away from deciding it.
My lord,
But in the meantime, we are not granting an interim order suspending the proceedings.
yes, my lord.
So by the time we decide it, assuming the proceeding comes to an end, what will be the effect?
I have already filed a representation, my lord, where I had expressed my protest, saying the matter is sub judice and it would depend the outcome.
That
of
is
the
always
litigation.
open to.
There is no
Lordship-
interim order.
Lordship,
There's no interim
You could
order,
have
but
gone and
if there's a
appealed.
final decision in the matter,
Lordship-
my lord. And-
if Lordship reads the previous paragraph, your Lordship, upon considering the submission made by the learned counsel for rival parties and on perusal of the materials available on record, including the authorities relied upon, I am on the prima facie view that the petitioner has not made out
We have
a
seen
case
that.
for the grant of interim stay, Lordship.
We have seen that.
This matter would require some hearing, my lord.
Some
Lordship
hearing
may
is-
fix it next week on a
We'll
hearing.
admit and fix it for hearing then.
My lord, Lordship would kindly fix a date, my lord, because the inquiry, like my learned friend said, the inquiry is about to get over. my lord.
It's
The inquiry-
concluded, Lordship, already. In my
The
instruction.
Lordship would,
verbal
this is
instruction.
one point, my lords, I'll come up with judgments wherein it has been stated by various high courts that if the presenting officer is interested in the disciplinary proceedings, he cannot act as the presenting officer.
That is a ground you urge when you put the proceedings, if it goes against you, you're presuming that it will go against you.
My lord,
You're presuming
my lord, my,
the inquiry report, for all you know,
my lord,
may absolve you of the charges.
my lord,
Then are you still going to press it?
my lord, I'm not on that. My lord, prima facie, my lord, the initiation itself is.
Answer the
Well,
question. Tomorrow, if the inquiry proceeding says no evidence, charges are no evidence
proved.
to sustain the charges,
my
you're
lord,
absolved. Will you still carry on this argument saying that
My
no,
lord,
no, that's not a valid
my lord,
inquiry?
the question put forth by my lordship, my lord,
You're
that is-
presuming that you'll
that is,
that the inquiry is going to hold you guilty,
that
which
is
is why you are challenging the appointment of the presenting officer.
That
We
will-
understand that.
the inquiry would absolve me is highly unlikely because of the.
Highly unlikely, but
In fact, impossible.
it's not a fact. It's not a,
My lord, the
it's
fact
not a
that,
fact as on date.
the fact that someone who's interested and.
We
who
can
has a-
we can only defer the matter. You wait for the outcome and see what happens.
The fact that someone who has apparent malice animus against me has been appointed as the presenting officer itself goes on to show, my lord, that the inquiry is not conducted in a fair manner. The lordship would decide
The
that.
inquiry to be conducted in a fair manner would be evident when the inquiry report is available.
My lord.
Inquiry report will be available when the inquiry is completed.
Yes, I totally agree, my lord. Normally,
So if you agree, then we close it.
What I've understood, my lord, what has fallen from your lordship, that unless and until there's a report of the inquiry officer against me, there is as such no cause of action.
We are not saying that.
My lord.
We are saying that because the court had declined an interim order, the matter has proceeded.
Yeah.
If it is your case that notwithstanding the interim order not being granted,
My lord.
inquiry has not gone to that level that it cannot be scrutinized.
Yes.
If the inquiry is over, waiting for a report,
Mm.
why should we
My lord, otherwise-
jump into a conclusion?
Otherwise, I totally agree with your lordship. Normally, in service jurisprudence, inquiry reports are also not challenged. The entire disciplinary proceeding is challenged after a person is held guilty. But now, my
Exactly.
lord, it is apparently, my lord, without jurisdiction. That is the reason why it was challenged.
You agree with me and then you disagree.
My lord would fix.
Lordship, even
Next
the
week, my lord would
university
fix
is
a
also
date.
in anxiety.
I'll try and satisfy your lordship, my lord, because my learned court has held, my lord. Lordship has seen the order. There's a question of law which has to be decided. by
We
the
can
court.
admit it for hearing if you want.
My lord, would kindly next week, lordship, an effort may be.
No,
made
we
to-
cannot give a priority for this hearing. Sorry.
In fact, that has already been given in the order, my lord. It says.
No, it says it has to be heard. Doesn't say it has to be heard out of priority,
My lord, it says,
out
so
of
that
third.
the matter can be decided at an early date.
Exactly. 22 matter.
My lord, first week of October, kindly.
We don't know. We can,
On the
we'll not
hearing
fix a
date,
date, we'll list it after 2 weeks. Heard learned counsels for the party. The challenge before the court is the appointment of the presenting officer. Presenting officer
presenting officer.
in the inquiry which is initiated against the petitioner. Stop. Learned counsel for the petitioner submits that because of reasons, because of grounds pleaded in the writ petition, there is a strong apprehension that the presenting officer appointed in the disciplinary proceeding is heavily biased against the petitioner. And therefore he submits that there is every likelihood of the inquiry being conducted in a very biased manner against the petitioner, causing wrongful loss to him. Stop. Under such circumstances, he had approached his court, praying for appropriate orders. This court, while issuing notice, had declined the interim order by order dated
23/9/22,
23/9/2022.
2022.
Stop. Mr. Das, learned counsel appearing for the university.
Lordship, 1 and 2.
University
Yes, Lordship.
submits that the inquiry is proceeded in the manner. Proceeded in the meantime, as there was no interim order suspending the departmental inquiry. And the matter is likely to be concluded within a short date. Mr. Mazumdar,
Correspondent with 3, my lord.
higher education.
No, my lord, I appear for the presenting.
The presenting officer in person.
In
Oh,
person.
You are not biased, is it?
My lord, my humble submission, if I agree to him, the presenting officer is required to be biased. He represents the department. He will have his defense assistant. The
I'll answer
inquiry
that.
officer is not to be biased.
I'll answer to that. My lord, first of all, my lord,
Otherwise, why be?
Presenting officer is to present the case.
Yes, my lord, whatever comes from the department, I'll present.
That cannot be
So that
perceived to be biased.
So that will not be a bias. So that is why I'm saying, when I represent the department, the apprehension of a bias will always be there.
No.
my lord,
I cannot cut it out.
He goes beyond that.
He
insofar
has to
as,
show that.
insofar as bias is concerned, my lord, I may not show bias, my lord. If I can show that there is likelihood of bias, that is enough. And secondly, my lord, he's saying that because being the
You want
presenting
the
officer,
court to substitute the inquiry that is going
my
on.
lord, the presenting officer, he's saying that I can be biased, my lord. That is totally a wrong statement because he appears for the government. It's Article 14 and there's a
Very well,
duty
very
to
well.
act
We
fairly.
are not hearing the matter.
He has a duty to act fairly. I would have understood, my lord, private company.
You must permit other councils to also submit
My
whatever
lord,
they
I'm so
want.
sorry.
So, Mr. R. Mazumdar appears for respondent number so and so.
Three.
Accordingly, matter be listed after we admit it for hearing.
Your lordship would make an endeavor to dispose it at the admission stage. Kindly, my lord.
We can endeavor at the hearing stage also.
I'll leave it to your lordship. Even they agree after 2 weeks, my lord, on a hearing.
That's
date.
out.
I'll be very grateful.
Tuesday,
sir.
Thursday. Red list on so and so day.
So
12th
hearing date is
October.
okay.
List on 12th October. For
Yep.
admission.
Deeply obliged.
May it please your lordship. This matter pertains to my lord, some DRS benefits, my lord.
Some?
Let-
Here
Yes,
is.
some, my lord. Because my lord, some of the benefit has already been given, my lord, but the house rent allowance and medical allowance has not been granted. And in addition to that, my lord, for 9 months, they have getting lesser amount, my lord. In this regard, my lord, kindly have a look at page, my lord. At page 37, my lord. Annexure 5, here. The members of the petitioner union has got the information regarding closure of the mill, my lord, by dated 29/9/2011, my lord. Herein it is mentioned that with reference to the subject cited above, I have the honor to inform you that Assam Cooperative Spinning Mill Limited, Waitamari, is declared closed by the gov notification by dated 29/7/2011. But my lord, kindly have a look at page 41, annexure 8, my lord. Here, joint register cooperative societies has communicated to the chartered accountant engaged, my lord, by dated 13th May 2019, wherein it is stated the balance sheet audited account submitted by you, the calculation of VRS of the ex-employee are found to be calculated up to 31/7/2011. As per your note submitted to this end, therefore you are requested to recalculate VRS and other dues up to 30/10/2010. That is till the date of liquidation. After that, my lord, the CA has prepared
You have
again.
received some amount.
Yes, my lord.
Now some other amount, according to you, is receivable.
Yes, yes.
What is the stand of the department?
My lord, the corporation department has filed their affidavit, my lord.
Hmm.
Yet they have stated only that the CA has engaged and the calculation has been made by the CA and accordingly the amount has paid.
Are you filing any rejoinder affidavit?
No, no, my lord, I think not required, my lord.
They have not admitted to your claim.
Directly not, but
Then?
nothing has been stated against me, my lord. My lord, kindly see paragraph 22 of my read petition, my lord,
Para 22.
at page 18, my lord.
Yes.
Here, my lord, I have stated, my lord,
Yes.
stated that the petitioner union had agreed, having no other application alternative remedy or remedies, approach the honorable court under Article 226 of the Constitution of India for justice, which is numbered as 22. After hearing the parties, the honorable court disposed of the read petition with my lord, paragraph 21. The petitioner begs to state that at page 18, my lord, it says 1/8/2011 submitted representation to the principal secretary to the government of Assam Corporation Department demanding release of unpaid salary and other allowances payable to the employees and workers of the mill, and a copy of the same representation has been submitted to the Register of Cooperative Societies, Khanapara, Assam. In representation, they have referred to letter number 76/2011, whereby on 26/2/2011 the Cabinet Committee of the Government of Assam has declared closure of the mill, but it has not made any whisper regarding payments of unpaid salary and other allowances payable to the employees of the mill. Therefore, in the representation, the petitioner union has paid for payment, release of unpaid salary and other.
Yeah,
I have-
yes, Mr. Counsel, what do you say?
Lordship, I have filed my affidavit, your lordship. As on date, your lordship, amounts have been released on 3 occasions. If your lordship kindly come to annexure D of my affidavit, page number 73.
Yes.
On that particular occasion, that is on 22nd of March 2012, an amount of rupees 40 lakhs has been released.
Hmm.
Subsequently, on 25th of January 2016, another amount of rupees 4 crores 72 lakhs 82,000 has been released.
Page number.
Page number 74, your lordship.
Yes.
Then on the next page, page number 75, another amount of rupees 17 crores 16 lakhs 67,000 has been released. That apart, your
What
lordship.
is the total dues?
Total dues, your lordship, if your lordship kindly come to annexure E, page number 76, your lordship.
Uh,
The VRS calculations has been recalculated by the chartered accountant firm as per notifications of 15/2/2006. That is the notification of the Public Enterprise Department, your lordship. Here, if your lordship kindly comes to page number 78 of my affidavit, your lordship.
hmm. Where is the amount? You go through it. List on Friday.
Okay.
Enabling learned councils to complete their instructions. Mr. Soikia for the petitioner, Mr. Borderland. Respond. Friday.
May I please, your lordship? Lordship, on the last occasion, the Director of Secondary Education had asked for a detailed report from the IS, your lordship, IS Jorhat. Only yesterday it was sent, your lordship. This is the forwarding, your lordship, with all the detailed reports. your
Sent from, received from inspector.
Lordship.
So what details, what you read it out?
Lordship,
what instructions?
lordship, some time may be given because that is under process, your lordship.
Mr. Chaudhary, what do you say?
There is the dues of salary, my lord,
Area salary, your lordship.
the annexed to the.
Your claim is for 12 lakhs. or-
Yes, my lord.
Lordship.
That was the calculation made by the directorate, my lord. Now I have annexed this sheet, the entire sheet.
They have received some instructions. Let them, you want to
Some-
bring it on record?
Lordship, this may be brought into record because this was sent from the inspector of
So
schools.
what
to
is
us.
this that I'm asking you? What is it?
Lordship, that the detailed report has been sent to the Director of Secondary Education. And that is what it has been stated, your lordship.
So
It is from
you,
the inspector of schools.
you complete, let her complete the instructions in respect of the, what report has come.
To come on Monday, my lord,
Some time may be given, your lordship, because
We can have it on 25th,
because
25th,
lordship,
25th.
lordship.
Mr. D. Chaudhary, learned counsel for the petitioner, assisted by so-and-so. Ms. MS D. Mushari, learned counsel appearing for
Secondary Education Department.
secondary education submits that instructions have been, the relevant records and documents have been called for. Which has been called for from the office of the inspector of schools,
Jorhat,
has been received yesterday.
lordship.
She requires some time to complete her instructions.
Okay.
Prays for a short date.
Lordship.
Let accordingly, Mr. Chaudhary doesn't object to the prayer made. Let's the matter be listed again on. Let it be on 27th of September.
Okay.
For
Obliged,
admission.
your lordship.
May I please, your lordship? Lordship petitioner are appointed as a community resource person and subsequently he has been removed from his service. And as per order dated 17/3/2003, the respondent are obtained to information.
Respondent are
Obtained to information. Instruction.
yes, respondents.
My lord, as far as his nature of appointment is concerned, my lord, his appointment letter is not annexed along with his writ petition. So whether if he's a individual who has been appointed against a regularly sanctioned post or whether he's a.
Do you not have any records in your office?
My lord, that record I'll have to summon from my department. We'll file an
That is what
affidavit.
you are granted time for by the last order as far back as March.
He's a contractual employee, my lord, at best. So if his agreement has lapsed, then anyways, he's not entitled to reinstatement. We'll get the records by the next date, my lord. There's appointment letter and whatever it is.
Mr. Handek, learned counsel for the where is the order, impugned order? Impugned order,
That's page 17, lordship.
No, no, no. No, 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 no.
Nine.
Fine. Have the inquiry.
You file your affidavit, you've been directed to file an affidavit.
Do they need?
Mr. Hendrik, Learned Counsel for the respondent department, prays for further 2 weeks' time to file affidavit. Mr. Ali,
Yeah, Ali Lord.
K. Ali, for the petitioner does not object to the prayer made list after 2 weeks.
Obliged. Lord.
Yes,
A small amount is here in this case only. Sir,
area salary. Yes, any instruction?
it's a 5-year lottery per use. That
Last order, you were required to,
Lordship, to get
Yep.
the update, your lordship.
yes,
Lordship, the proposal has been sent from the Director of Secondary Education
to,
to the Secretary of the Government of Assam, Department of School Education, your lordship. So
only,
it is still under process.
only 2,73,327, as per calculation, annexes 7. The lordship may kindly see. Okay. At page 20.
that is the amount pending.
Pending.
Lordship.
That amount, your lordship may dispose of the matter, the calculation.
You give us that
Lordship.
instructions. Okay, I heard learned counsels, Mr. D. Chaudhary, learned counsel. Commissioner, and Ms. D. Musari for the respondents. This writ petition is filed by the petitioner. Praying for a area salary, which according to him, he is entitled to because of revision of his pay during his service rendered as assistant teacher in Solmara Government IB School, which was subsequently merged with Solmara Higher Secondary School. Stop. Learned counsel for the petitioner submits, he was appointed as an assistant teacher in so-and-so school in the year 1978. Subsequently, the said ME school was merged with Solmara High School by way of amalgamation. The pay payable to the petitioner was revised in 1981 with effect from 1st January 1981. Stop. Subsequently, his services were upgraded to the post of a graduate teacher with effect from 28/3/1994. Stop after his graduation, after the upgradation. His pay scale was fixed at 1375 hyphen 3375 per month with effect from 28/3/1994. Stop. The said pay was again revised in 1996. And in 2016. his revised pay was refixed as per notification by FPC 42-2018 hyphen, not hyphen slash 2018/3 dated 9/3/2019 issued by the Department of Finance, Government of Assam. Stop. As per the said notification, his initial pay with one increment was fixed at rupees 60,500 as on 1/7/1996.
2006.
Stop. The amount so increased as per the refixation notification dated 9/3/2019 has not been calculated and assessed during the service tenure of the petitioner. Stop. He ultimately superannuated on 31/12/2019. It is submitted by the learned counsel for the petitioner that the arrear amount which was increased in the pay scale of the petitioner as per the MSCP scheme was not assessed, and consequently the amount payable to him was not released till his retirement. Stop. Even after his retirement, in spite of representations furnished by the petitioner, in spite of requests made, the amount has not been finalized and released. Stop. The petitioner thereafter submitted his representations before the authorities concerned. And as per the particulars furnished by the principal of Solmara High School, the entitlement has been assessed and shown at rupees 2,73,276. A non-royal certificate by the treasury officer has also been issued, but in spite of that, the amount as reflected and held to be payable to the petitioner has not been released. Being agreed, please file the present application. Notice in the matter was issued on 2003/2023. Para MST Mushari, learned Government Council appearing for the Education Department, has submitted communication number so and so dated 27 July 2023, whereby the Director of Secondary Education has submitted proposal for release of area salary within bracket fixation of pay and MSCPS bracket close area in respect of the petitioner, who is a retired assistant teacher of Solmara High School. Stop. The said proposal was forwarded to the Office of the Secretary to the Government of Assam, Department of School Education. Stop. Para, a perusal of the said communication placed before the court reveals that the relevant papers that a proposal has been forwarded for releasing the amount of rupees 2,73,276 as area salary within bracket fixation of pay and MSCPS area. MSCPS bracket close area in respect of the petitioner. The proposal also encloses the non-roll certificate submitted by the principal, which is duly countersigned by the Treasury Officer Belsor. Stop. The head of account to which the expenditure is debitable is also mentioned in the said communication. Stop. Para. The communication as forwarded from the Office of the Director Secretary, Secondary Education, he reads as under expect. Para, having heard learned counsel to the parties, it is seen that the proposal has already been forwarded to the Secretary, School Education. Stop. Learned counsel for the respondent has fairly submitted that the matter is under active consideration and necessary sanction orders is likely to be issued within a short date. Taking all the submissions made before this court on record, this court considers it appropriate to close the writ petition at this stage with the direction to the Secretary, Department of School Education dispute. Secretary, Government of Assam, Department of School Education dispute to forthwith pass necessary orders sanctioning the proposal forwarded by the Director, Secondary Education Assam, Kaili Para, as per provision of law. Stop. Once the sanction is received, the necessary payment required to be paid to the petitioner should be released without further delay. With the above observation, writ petition stands disposed of. The directions contained be complied with within a period of 60 days from the date of receipt of a certified copy of this order. The petition stands disposed of in terms of the above.
Obliged, Your Lordship.
My pleasure, Lordship. Lordship, matter pertains to the non-disbursement of the pensionary benefits gratuity limit encashment, my lord.
They filed some affidavit.
Yes, there is one affidavit, my lord, but my humble submission, my lord, this wouldn't be sufficient, my lord, because the Medical Education and Research Department would be the best person to give their answers, my lord.
Yes.
Because, my lord, it's a second round of litigation, my lord. Earlier, my lord will get the operative part at page 65, my lord. My lord, the petitioner has resigned from his post after rendering 10 years of service from the Medical Institute of Jorhat, from the post of junior teacher. Thereafter, his resignation was not accepted. Then he approached before this honorable court, and this honorable court has observed it at para 6, my lord, page 65. Accordingly, this writ petition stands disposed of by directing the Commissioner and Secretary in the Health and Family Welfare Department to consider and pass a region final order on the letter of resignation of the petitioner dated 02/01/2021. If the resignation of the petitioner is accepted, it be deemed that it was accepted from the date the letter of resignation was submitted, and consequential pensionary benefits be provided to the petitioner accordingly. There was a clear order, my lord. On the other hand, if the Commissioner and Secretary is of the view that the letter of resignation is not accepted, a region order be passed and be communicated to the petitioner. Thereafter, they have passed a speaking order, my lord. My lord will get it as page 80, my lord.
Yes.
The third para from bottom, my lord. As reported by Principal Medical Institute Jorhat, Dr. Sandeep Barali was paid his salary up to 31st December 2020 and no outstanding were detected against his name at Medical Institute Jorhat. That was the information by the principal who has filed this affidavit, my lord, here. And the final, what is the view, my lord? At page 81, if your lordship, I will look at page 81.
Yes.
Again the third para from the bottom, my lord. In view of the above, and after careful examination of the direction of the Honorable High Court, and also the records available with the department, Medical Education and Research Department has decided to accept the resignation letter in respect of Dr. Sandeep Barali, Junior Teachers, Medical Institute, Jorhat, with effect from 02/01/2021. The date the letter of resignation was submitted by Dr. Barali. However, Dr. Varali will be liable to clear outstanding dues to government of Assam if any such due emerges in future. But there was no mention about the benefits, as Honorable High Court has directed it that if they accepted it, they have to pay the benefits, my lord.
Now, what is the affidavit?
My lord, in the affidavit, what they have stated, the principal has filed the affidavit, my lord, the principal of the Medical Institute. At paragraph 3, my lord.
Petitioner, his resignation was accepted by the government on 2/1/2021. As per our affidavit, paragraph 3, last paragraph.
Yes.
May I read, my lord, from paragraph 3, the second paragraph, my lord. In view of the above, it is respectfully submitted that the petitioner had worked as junior teacher, Medical Institute, Jorhat, from 14/12/2010 to 02/01/2021, and his resignation was accepted by government with effect from 02/01/2021. In connection with the petitioner's pensionary benefits and gratuity money, the petitioner is required to submit the same through proper channel. Required documents, that is pension papers, Form 5, and undertakings to make good any overpayment of the payments, which is not eligible to the concerned sanctioning authority and also the pension accounting officer of
You
the
submit
LC,
it.
my lord.
You submit
My
it.
lord, we will submit, but where there is a clear-cut direction from this honorable court, but in the speaking order, they have not mentioned it is submission of my
This
documents,
affidavit,
required documents.
this affidavit says you have to submit.
My lord, we will submit it.
Hmm.
But regarding withhold of the terminal payment from my contributed pension under the new defined contribution pension scheme, they are not mentioning about anything or saying anything. So that part may be the medical education.
Is
and
something
research
withheld?
department, my lord.
Is any amount withheld?
Actually, conducting counsel is not well today, but affidavit, apart from affidavit, I cannot say anything.
So in the affidavit, is there anything mentioned that it is withheld?
No,
No,
no.
Then why are you apprehending?
but I'm not allowed to withdraw that amount, my lord.
You apply through the proper
Yes,
channel.
My lord, already there is a direction from this honorable court, my lord,
Uh, Direction to what?
to disburse, my lord.
Where is
At-
that order
At
again?
page 65, my lord.
Page 65.
Already, I have read it, my lord. If the resignation of the petitioner is accepted, it be deemed that it was accepted from the date the letter of resignation was submitted, and the consequential pensionary benefits be provided to the petitioner accordingly.
Provided by whom?
Provided by the authority, my lord.
So
Provided by,
you will be provided you apply.
My
You
lord.
apply whatever forms, the formalities are there, you apply. Court did not say that it will be provided the moment it is to be accepted, it must be reflected in your account.
and in the second paragraph at page 85, my lord, what they have stated in the matters of 2 advance increments, specific payslip from AG office, along with the sanction order
You
from,
first submit your documents.
my lord, I will submit it.
Ah,
But regarding the second paragraph, my lord,
Page number
page number 85, my lord.
85.
Second paragraph, my lord, in the matters of two advance increments, specific pay slip from AG office along with the sanction order from the government are needed, which is lacking as of now. So AG would be the best person, my lord. And next, my lord, it is also respectfully submitted that as of now, the petitioner has not submitted the said required documents.
You
to
first
the-
submit the documents.
Yes.
Why don't you submit the documents?
My lord, first, we'll submit it, my lord. But
You submit
regarding the two increments, my lord, advance increments, and regarding the withhold, my lord,
There is no,
withholding of the pensionary benefit, contributed pension from my pension account number, that cannot be done, my lord.
You submit the documents first. You submit the
My lord.
documents, then let us see what orders are passed.
Till that lordships is keeping pending this matter,
It is up to you. You want a disposal, we dispose it.
my lord may kept it pending, my lord.
In
Today direct-
terms of the earlier order dated so and so, where is that order, earlier High Court order?
Page 61, my lord, start from page 61, order dated 24/6/2022.
24/6/22, passed in WPC 4150/2022. This court directed the authorities to pass necessary orders. A reason of final order on the letter of resignation of the petitioner, which was submitted on 2/1/2021. And if the letter of resignation was accepted, then consequential pensionary benefits to be provided to the petitioner accordingly. Stop. Pursuant thereto, the department had, after conducting a hearing, passed the order. Where is the order? Dated
Madam-
17 November 2022,
page 80, Lordship.
by which the resignation of the petitioner was accepted with effect from 2/1/2021, which is the date on which the letter of resignation was submitted. Stop. Learned counsel for the petitioner submits that in spite of a clear direction by the court, his pensionary, in view of the acceptance of the resignation letter, his pensionary benefits, etc., had not been released by the department. Stop. Being aggrieved, he has filed the present writ petition seeking appropriate writ direction or order. Para. Pursuant to the issuance of notice, the respondents have, the respondent number 9, namely the
Yes.
Principal Medical Institute of Jorhat, had filed their affidavit. Whereby it is stated that after acceptance, after the petitioner's resignation was accepted, the pensionary benefits and gratuity amount of the petitioner is to be released upon the petitioner submitting the required documents, namely pension papers, Form 5 and other undertakings to make good any overpayment or payments to which he was not eligible to the concerned sanctioning authority and the pension accounting officer of the AG office. Stop. Such papers have not been submitted by the petitioner. Para. Mr. Medhi, what is your name?
My lord, Decker,
Decker,
BM Decker.
in Mother's.
Mr. Swansol and counsel for the petitioner
Why they-
submits that he will, the petitioner will furnish the necessary documents as required. In the meantime, liberty is granted to the petitioner to submit the necessary papers seeking pensionary and other benefits. Upon such documents being submitted, the respondent authorities, including the AG office,
Lordship, in this case, he is in the old new pension scheme, my lord. His appointment was in the year 2010, my lord.
Yes.
So Lordship, so Accountant General has no role to play in this.
all right, the respondent authorities will do the needful for releasing the pensionary benefits and gratuity amount of the petitioner. In that view of the matter, the matter stands deferred for 4 weeks, enabling him to file the necessary documents.
My lord, a duration may be fixed for disposal of the pensionary benefits. my lord.
We can dispose it off if you want. That is what we said.
My lord.
Or you file it and
No, we'll file it.
come back after 4 weeks.
Much obliged. my lord.
Mr. Mazumdar, Talukdar appears for the
Number 8, my lord.
respondent number
8, my lord.
8, Mr. Borpuzari for
5 and 6.
respondents 5 and 6. Mr. Borua,
I'm present.
respondent 7.
I'm 1 to 4, not
Sorry,
1 to 4.
Madam
and
appears
9.
for 1 to 4.
4 and 9.
Much obliged. my lord.
Yes,
Lord, all this matters relates to termination of the employees of Assam State Transport Corporation, my lord.
Not all the employees.
760, 771.
yes, then
Well, so far pleadings are concerned, pleadings are complete and it is ready for disposal.
we'll admit for hearing.
Since they have terminated us without any inquiry, I will only pray that your lordship will fix it and I'll eat it.
Let us admit it will come for hearing.
All this, they all employ, some are conductors, some are security staff. And in one case, there is even an interim order.
This is the matter which will require full-scale hearing. So
Yes.
there's no point keeping it for admission. So we'll keep it for hearing.
Yes, ma'am. Any day convenient.
Admit,
but
hard learned counsels admit. Matter be listed for hearing. In the month of November.
The second week of October.
No. Second week of,
First, my lord, may we take a chance on, my lord, 5th of October, Thursday?
5th of October, we have already several matters.
Motion method.
Wonderful. 10th of October?
10th of October.
10th, huh?
No, Lordship, after reopening, Lordship.
What-
On those last matter, Lordship,
what-
otherwise also Lordship will take up only motion matters, Lord.
No, they are not prejudiced by taking up the matter on 10.
No, every time, Lordship, my colleagues are taking time.
No.
They are fixing time. No, Date are fixed by them only, Lordship. We are not fixing, they are fixing date.
No, don't put words in our mouth. It's the
No,
court.
they are
who
fixing
is
dates,
fix-
Lordship. We are
the
not
court
fixing
is-
dates.
The honorable.
So I
court
am
has
only
fixed-
submitting, Lordship, not immediately prior to the vacation, Lordship. Let these matters come after vacation, Lordship.
These people are terminated.
Yes,
Yes, yes, they were contractual employee, Lordship. Once it is decided
Oh,
not
you
to
will
extend
keep
the
the
contract,
concern-
it is decided, terminated, Lordship.
On
Not even terminated, released.
Let us
Lordship.
have it on 12th.
Lords.
Let us try
Yes.
on 12th.
No, my difficulty is, Lordship, in this matters, Lordship, I am assisting learned advocate general, Lordship.
Let them start or at least,
Lordship.
there are several matters, they may not be over on 12th.
Lordship.
Let us have a beginning, my lord.
We'll have it on 12th.
Deepak.
Item 47, there is an interim order protecting us. That should continue.
Interim orders wherever will continue till the next date fixed. Respective councils for the respondents, Mr. Nayak, MP Bora, Mr. Das, Mr. Borua also? No.
I'm there.
No, we are recording your names. Kindly give it in a slip.
No, we'll write it.
Yes, item wise.
So here the grievance of the petitioner pertains to non-release of his increments. His arrear salary has been released since the year 1998 in the year 2013. But the increments which are due along with the salary that has not been released.
Why not release the increments?
Your
Here,
lordship-
my lord, proposal has been submitted by the district elementary education officer. It is under process, my lord. Verification is on.
How long will it take?
My lord, some time may be needed, my lord.
Why?
Budget sanction is required, my lord.
Lordship will kindly peruse the order dated 36/23. They were directed to file their affidavit.
On what basis are you making this submission? Some instructions are available.
My lord, I have received a communication, my lord.
To say what?
Lord, here, my lord, I'd like to say that DEO Nagaon submitted the area proposal of amounting rupees 11,82,000 and 78. Only in respect of the petitioner, Mohammad Mukhtar Hussain, assistant teacher, simultaneously MEM under BEO Julia Nagaon district through WhatsApp. The necessary verification of the said proposal is being under process and the proposal will be submitted to the government to accord sanction after receiving original proposal from the DEO Nagaon subject to the budget provision to be provided by way of supplementary demand under the respective head.
So why do you have to write in such cryptic language? Tell us what you want to do. Do you want to release the payments or you don't want to release? First, the proposal is sent,
My lord,
then you want a verification. Then you'll wait for the original proposal to come.
My
What
lord.
is the meaning of this?
actually original proposal has to receive from the.
Then
district.
why have you stated the proposal has been sent?
My lord,
Is it a duplicate proposal?
No, my lord, it's through WhatsApp, my lord. That is why, my lord. As per this instruction, I am submitting, my lord.
No, as per this instruction, which you just read out, I am asking you, there is a mention about original proposals being received.
My lord.
What is that original? To be received by whom?
My lord, that has to receive by the director, my lord, from the district.
And
elementary.
who has given you that instruction?
This has been given by the director elementary education.
He has received the proposal through WhatsApp.
My lord, here as per this communication, my lord. My lord, some time may be given, my lord, I will bring the exact my lord, instruction, my lord, what is going on, my lord.
Friday.
Friday, my lord.
You have to only find out what is the status.
Yes.
Tell us.
My lord.
What status, what are they doing? Sending the proposals, duplicate, original, triplicate, whatever is there.
Yes, only that much they have to.
Hmm?
Friday.
Friday.
If possible, 1 2 weeks, my lord.
Only to get the
Yes,
information,
my
what is there?
My lord, I'll try to bring my.
Hmm?
I'll try to bring.
All right, Friday. List on Friday, enabling the learned counsel for the respondents to obtain instructions as to the status of the proposal for arrear, no, for increment.
Increment. area.
Increments in respect of the petitioner which has not been released as on date. MSD Borgoi appears for the petitioner and learned
PK Boy.
counsel appears for the government advocate,
No, it's saying council elementary education.
standing counsel elementary education. List on Friday, 15th.
Published.
God bless me.
Yes.
Your lordship. Here, the respondent number 6 have filed an affidavit in opposition, your lordship. In response to that, we file affidavit in reply, your lordship. So
So-
already ready, your lordship, I'll file tomorrow.
Huh?
Tomorrow I'll file.
Tomorrow you'll file. All
Yes,
right.
lordship.
Mr.
Already ready.
Borua,
Yes, lordship.
learned counsel for the petitioner submits that the reply affidavit will be filed within this week. Mr. Das appears for the respondents. NC Hills. Are you also appearing?
I'm appearing for respondent number 4, D. Rabha.
Mr. Rabha appears for respondent number 4. Matter be listed after 1 week.
Please, your lordship. Lordship, matter pertains to apportionment of pension, lordship, between two wives, lordship. Petition number 1 is the second wife and petition number 2 is the
daughter, Lordship, of deceased government employee, Lordship.
Petitioner one,
Is the second wife of deceased government employee, Lordship.
and petitioner two
Is the daughter, Lordship,
of
of the deceased government employee,
born out of the second wife.
second wife, Lordship.
So what do you want?
Lordship, this point has been settled by the full bench, Lordship, regarding apportionment of pension, Lordship. And now this petition may be disposed of in the light of.
Do you have the judgment?
Lordship.
Second party, what is the next one? Nota waiving কথাটো কৈছে তাততো এপৰ্টমেণ্টৰ কথা কোৱা নাই নহয়
Heard learned counsels for the parties. Yes, Mr. Borua,
Lordship,
full bench judgment.
Junopar will be Lordship. But it is not directly Lordship for apportionment, not directly said Lordship.
No, entitlement. This is for entitlement.
Second wife.
No, not second wife. It is as per 143, it is the eldest of the surviving widows. So you decide who is the surviving widows and pass, release pension.
So perhaps the first wife is getting the pension. No?
She's getting the pension.
And she has made a party here, I don't know. Sir.
Who's for the that first wife?
Whether service has been complete or not, because it has come for orders.
We have served dusty notice, Lordship, but she did not turn up.
Lordship. I don't want to talk also. What happened to that? Lordship, no next of kin certificates also annexed to the petition.
You examine it in terms of the judgment. We are closing it. Have you rejected her case?
I don't. Okay, because procedure is that once when we issued a PPO, Lordship, in the PPO itself, we reflect the name of the family pension holders.
Kindly read para 22 of the judgment. What is this IA for?
IA regarding Lordship, directing the respondents not to pay 66% of pension amount to the respondent, private respondent number.
What is
5.
66%? What 66%, Mr. Sheikh?
That 3 persons, my lord, 2 wives and 1 daughter.
Who has apportioned this amount?
We pray that 66% belong to us, that is the second wife and daughter. So that should not be paid to the first wife till disposal of the deed.
On what basis that calculation is made?
Calculation, my lord, this is that leaving 3 sharers.
Hmm?
3 persons left out. The first wife, second wife. and
You enter in any calculation, any agreement with your,
daughter.
with the parties.
That is on.
We go by the pension rules.
The calculation. my
No,
lord.
we go by the
Persons-
pension rules.
3 persons are equally entitled.
Under what provision? Under what provision of the law are you claiming this? Are you claiming an order from this court?
family pension rule, my lord.
There is no percentage.
I'm not for the, in the writ petition, my lord, I'm not praying that 66%.
Ah, but you are praying.
I say. in
You are
the
praying, it
interim-
is there in your
interim,
prayers.
That should be blocked. But
Why should we block
ultimately,
it?
ultimately, my lord, in the final, your lordship will decide what I am entitled to
You are entitled to what is being decided by this court.
by the full bench.
So in that in context, your writ petition merits dismissal.
Not merit disposal, my lord, but it is your lordship. judgment.
23, paragraph 23
My
says
lord,
about the
my
appropriate
lord,
forum.
here,
Chief.
What Fullman said, my lord. Fullman said that first wife will be entitled. But it does not mean the others are ousted. Other will also entitled to maintenance. If the maintenance is not properly paid to the second wife, in that case, that they may come to the appropriate court.
Which is that
maintenance.
appropriate forum?
Well, that is not, that is the
Just a
difficulty, it is not said. What is the
Uh,
appropriate?
We can't say it, we can further clarify this order.
forum?
Court says appropriate forum.
Well,
If you want clarification, you have to file an application seeking clarification or review. We cannot further clarify it.
That is the my lord.
We leave it to your wisdom to decide,
It is difficult.
but
from
we
the-
are definitely not, this bench is definitely not the appropriate forum for this.
Appropriate forum, just it is said appropriate forum.
Hmm.
What is the appropriate forum? That is not said by the full bench.
That's right.
And that is the difficulty.
No, that is a greater difficulty for us because we are bound by the full bench.
Full bench, yes.
So if you want further clarification, your remedy, you know your remedies. So we close this petition.
Madam.
We,
In the light of the full bench decision, madam, the petition may be closed.
Then also, paragraph 23, the
in the
appropriate-
light of the full bench decision, this petition should be dismissed. In the light of the full bench decision,
Madam, on that count, my lord,
hmm,
I do disagree, my lord, because here it is not said that I am not ousted. Full bench decision said that para 23, we also provide that event of any such other persons who are entitled to benefits of family pension in terms of section rule 143 of the pension rule 69, including the second or further wives. In case where the parties are governed by Mohammedan law are not appropriately maintained by the eldest surviving wife or wife to whom the pension would be paid. The remedy therefore would be to make a claim for maintenance in the appropriate forum under the law and not claim for payment of family pension by state authorities directly to such persons.
exactly.
That one. Lastly, yet, but however, if in a given case, the state authorities on their own volition are of the view that under an acceptable circumstance, the authorities are agreeable or required to pay the pension separately to any such member of the family of the deceased employee. This judgment may not be constituted to be an absolute bar on such separate payment. On this, my lord, my humble submission before your lordship, my writ petition is not liable to be dismissed. It may be disposed of in the light of the full judgment.
No, in the light, in
the-
what light?
There are 23, my lord. I will go to the appropriate forum for maintenance.
So do you need an order?
My lord.
By this full bench already gives you the
Well,
liberty.
If your lordship held that in the light of this judgment, my writ petition is disposed of, my writ petition is dismissed, meaning thereby that 23 will not come in my help.
No. We will say that in view of this full bench judgment,
My lord,
no orders are necessary in your petition. it
So-
should be dismissed.
That is my prayer before your lordship, that this writ petition may be closed in the light of the full bench judge, not dismissed. If it is dismissed, my lord, then I will be in trouble regarding this. I will not get benefit of 23, para 23. So your lordship,
Why
May-
is this an IA? Why an IA is filed here?
I filed because my lord, the case was not disposed of. In the meantime, first wife is taking the entire pensionary benefit. So we filed this petition. I filed that pension may not be paid to her to the 66%. That may be
Okay,
disposed
hard
of.
learned counsel for the parties. This writ petition is filed by the second wife of
Second wife and another daughter.
and the daughter of late, what is his name? What is the name?
I'm giving
Shah Alam.
Shah Alam teacher.
Huh?
Shah Alam was the teacher. Shah Alam.
No, what is the name of the husband and the father?
Shah Alam.
Shah Alam.
There are two, my lord.
Stop. The husband and the father, late husband and the late father respectively of the petitioners. He was working where? Where was he working? Sir?
Yes, my lord, I'm giving.
Paragraph 2, Lordship, page 5, headmaster of Topamari LP School.
Was the headmaster, was serving as a headmaster of so-and-so school. Pursuant to his demise, the private respondent number 5, who is the first wife. There is no dispute that you are second and she is first.
Yes.
The first wife had been claiming the pensionary benefits. Being aggrieved, the petitioner has urged this case, has prayed for appropriate orders from this court. Stop. An IA was also filed, praying for orders, seeking a direction to suspend the grant of pension to the respondent number 5.
At the rate of my lord,
Huh?
66%.
Not to grant pension at the rate of 66%
Yes.
to the respondent number 5. Stop. Para. During the pendency, when was it filed? It was filed later. Learned counsels at the bar have referred to a judgment, full bench judgment of this court, rendered in so-and-so versus so-and-so, reported in 2023 1 GLT, within bracket FB, 736. Stop. The learned counsels for the parties agree, fairly submit that the findings of the full bench rendered in the judgment, more particularly at para 23 and 22 and 23, will cover the grievances raised by the petitioner, will address the grievances raised by the petitioner in the present writ petition. Stop. Para learned counsels for the parties have been heard. The pleadings have been carefully perused. The judgment rendered by the full bench, decided on so-and-so, has been perused. Stop. In the said judgment, the relevant paragraphs of the said judgment is extracted below. para 15 onwards. So upon due perusal of the judgments as well as the pleading, and upon hearing the counsels for the parties, this court is of the view that the petitioners in view of the judgment, authoritative finding rendered by the full bench of this court in so and so versus so and so, the petitioner is at liberty to approach the appropriate forum for redressal of his grievances, of our grievances.
If maintenance is not paid by the first wife.
If you have grievances of your grievances, whatever grievances, stop. In view of the findings of the full bench, the prayers made in the writ petition cannot be allowed. However, as directed above, grievances, if any, grievances in respect of maintenance, if any, are permitted to be ventilated before appropriate forum as directed by the full bench. In that view of the matter, the writ petition stands closed. IA so and so also stands disposed of.
Very favorable. Okay, I verified the record load to the office note that the first of September the service is completed. So let me come up for admission. In the meantime, I suppose you directly to file FTV also.
As per Office Note 19/2023, service on
6 and 7.
respondents 6 and 7 has been held to be completed. Accordingly, matter be listed for admission. Respondents in the meantime may file their necessary affidavit if so advised. Mr. Deka for the petitioner and Mr. Talukdar for the respondents.
Obliged.
Yes.
Lordship, this matter relates to my discharge from service from Amguri Municipal Board, my lord. First, I was suspended from service, my lord. Thereafter, my lord, without inquiry, my lord, I have been discharged from service. The suspension order, page, my lord. Annexure to page 30.
Why is it for orders today?
My lord, the notice was delivered, served, but they had opted not to appear before this.
As per Office Note dated 7/2/2023, service on respondent 3 and 4 has been deemed to be complete. Accordingly, matter be listed for admission.
Now, similar case has been
accordingly,
disposed of. Similar case has been disposed of by this court. It may be disposed of in this like manner.
Give the order. Who's for the respondent?
I have for respondent number 1 and 2.
What do you say regarding the similar order? Yes. Where is the impugned order?
That is, my lord, at page 41, Annexure 4. my lord.
Where is the municipal board decision?
That has not
Reflected
been
there,
furnished to me, my lord.
not furnished.
Not furnished.
Who's for the municipal board?
This is Amguri Municipal.
There is a
They have not appeared, my lord. There is a- In spite of
Amguri
delivery of
Municipal
this
Board.
Amguri Municipal Board.
Do you obtain instructions? Let us see. Here the some show cause was issued.
There are so was issued. In this case, so was even not issued.
And that is what we want to find out from the department.
No, it is, my lord, basically the termination order, discharge order given by the chairman Amguri Municipal Board.
Correct. But there is some decision taken here. Municipal board decision 23-3. We want to see that order.
Yes, that they have not appeared, my lord.
They have not appeared, so we will request the government
yes,
council,
yes.
urban development, to requisition the records and place it before the court. Mr. Borwa,
Lordship.
hard learned counsels for the parties. This writ petition is filed by the petitioners, aggrieved by the impugned order dated 24-3-2020, whereby the petitioner, how many petitioners?
Only one.
Where the petitioner was working as assistant tax
Tax daroga, yeah.
daroga, has been discharged from his post with immediate effect for embezzlement of the board's own fund and destruction of the board's property. Stop. This order was passed pursuant to Amguri Municipal Board's decision dated 23-3-2020. Stop. Mr. Learned Counsel for the petitioner submits that no inquiry, no notice has been issued by the municipal board before issuing the termination order. Para Mr. Borwa appears for the respondents 1 and 2.
1 and 2. my lord.
Stop. Office note dated so and so reflects the respondents 3 and 4 have been served with the steps on respondent 3 and 4 has been taken, and the Lozima by order dated 7/2/2023 has passed an order whereby the service on respondent 3 and 4 has been deemed to be have been effected. Stop. However, none has entered appearance till date. Stop. Under the circumstances, we request Mr. Borwa, appearing for the respondents 1 and 2, to requisition the relevant records from the Amguri Municipal Board's office containing the proceedings relating to the order, impugned order dated 24/03/2020, whereby the petitioner was discharged from the post of assistant tax daroga. Stop. The records should also contain the Amguri Municipal Board's decision dated 23/03/2020, which is reflected in the impugned order. Stop. Let the records be placed before the court on the next date. Fixed. This order is passed in view of the fact that in spite of notices having been deemed to have been served on respondent 3 and 4, none has entered appearance. Stop. Let the matter be listed again on 27th, 29th September. Stop. Copy of this order be marked to the office of Mr. Borwa for onward communication and for calling for the records. Para. Mr. Ahmed Rahman further submits that a similar writ petition has been disposed of. Pertaining to Amguri. Okay.
Yes, same.
Same municipal board, whereby a coordinate bench of this court has passed an order on 2/6/2023 dated 22/04/2023. Copy of the said order is retained in the case record. Matter be listed again on 29th
It will come for admission, my lord.
for admission.
27/9, no? 29. 29.
29.
29. 29.
With your lordship. Lordship, I-
Amendment.
Lordship. I have not received a copy by the
You give her a copy, you've not served copies.
lordship.
You serve copies on Monday. You get your instructions, tell us if you have any.
Not on Monday, my lord, Tuesday or Wednesday.
All right, Wednesday.
Okay.
Yes,
There is a condonation of delay petition, lordship. 56 is delays, lordship.
notice served.
Lordship.
Have you taken steps?
Lordship, I appear.
Any objection?
No, Lord.
Heard learned counsel for the parties. This
M. Das.
IA has been filed seeking condonation of a delay of how many days?
56 is lordship.
56 days. In filing what? What is that? What is it that you're filing?
Lordship, page 5, para 5, lordship. Where for medical purposes, lordship.
Substituting legal aid.
Uh,
Substituting legal aid. Stop. It is submitted that the petitioner in WPC number 5343 of 2022 expired on 2009/2022. Stop. The present applicant is the wife of late so and so, who is the petitioner in WPC number so and so. It is submitted that what was the writ petition prepared for? What was the writ petition prepared for?
Terminating from service, lordship.
Remove for services, lordship.
Without pension. No pension.
No.
The writ petitioner was removed from service. And therefore consequently, no pensionary benefits are payable. Learned counsel for the petitioner submits that the applicant being the spouse of the late petitioner and a legal heir. Spouse and legal heir of the late petitioner. The right to sue survives, and therefore its IA has been filed, seeking substitution of the applicant in place of the petitioner. Stop. However, prior to filing this application, because of reasons beyond her control, there was a delay of 56 days in filing this substitution application. Stop. The application could not be filed within the statutory period of limitation. Stop. It is submitted by the learned counsel to the petitioner that pursuant to the expiry of the petitioner, the applicant herself required medical treatment and had to proceed to Delhi for her medical treatment. Stop. It is only pursuant to her return back from Delhi that she could pursue the matter for filing the application. Stop. Consequently, there was a delay of 56 days. Mr. Handick, learned counsel, appearing to the response, clearly submits that he does not wish to. There is no objection for the application. Praying for condonation of delay 56 days. Having heard learned counsel, and upon due perusal of the grounds urged, this court is of the view that the delay in filing a substitution petition has been sufficiently explained by the applicant. Consequently, the IA stands allowed delay of 56 days in filing the substitution petition stands condoned. IA is accordingly disposed of and allowed. Your substitution petition perhaps is not numbered. Is it numbered? All right.
May it please the lordship. Lordship, this is a long pending claim of the petitioner, wherein a direction was given lordship to pay or release the arrear salary for a period of 2005 to 2010 lordship. Relevant portion of the order, your lordship would find at page 15, my lord. Page 15.
Yes.
Page 15, para 2. The matter pertains to the claim of the petitioner for payment of arrear salary of the petitioner for the period from 1/4/2005 to 31/3/2010 for an amount of rupees 7,20,488. It has been submitted that the aforesaid amount is not disputed by the authorities, as it evident from the order dated 28/1/2011, Annex A2 of the Director of Elementary Education, Assam Kahalipara, Guwahati, which has been mentioned below. In the next page, lordship, page 16, my lord, the last paragraph, page 16, last paragraph. However, considering the materials on record, this court is of the opinion that since the aforesaid amount has not been paid, the respondent authority are directed to make payment of the aforesaid amount, which shall be done within a period of 4 months from the date of receipt of the certified copy of the order.
Yes, what happened, Mr. Muzumdar?
My lord, the matter is actually being represented by Mr. S.M.T. Christian and Mr. B. Kaushik. They're both on legs. My instructions are, my lord, it will be taken up on the next week. There seems to be some difficulty in the proposal from the district level. We should have.
You tell us a date. 27?
Yes.
27.
Lordship.
Matter will be listed on 27. When who is appearing now?
Mr. S.M.T. Chisti, my lord.
We will record your name.
My
Mr.
lord.
Muzumdar submits that instructions in the matter will be furnished in the next date as regards the compliance. All right.
Obliged. In item number 69, perhaps there was a misunderstanding of the order in the department. What they did was they were awaiting for proposals on the format prescribed for payment. Well, the order of the court was only for disposing of a representation.
By passing
That-
speaking order.
The speaking order part was not done for some reason. My lord, I have instructed them today. Maybe a week or two, my lord, we should have the speaking order on the court.
Where is the order?
Subsequently, my lord, the petitioner appeared, my lord. Yes,
Where is
there
the order?
Order, my lord, page, my lord, property 45, my lord. Yes, 45. Order dated 11 portion, paragraph 8. In view of the above, decision is disposed by directing the petitioner to submit a detailed revision along with supporting documents before the respondent number 3. Now, my lord, the present, my lord, respondent number 3, my lord, present incumbent. Within 2 weeks from today, explaining the reason which prevented him from attending the school from 10/9/1997 to 9/8/2000. On receipt of such reason filed by the petitioner, the respondent authority will consider the and dispose the
We
petitioner.
record that some order has been passed in the matter.
My lord, the department, I'm not sure that they have passed the speaking order, my lord. I'll be honest, my lord. What has happened is he has been called twice or thrice for hearing also. Not that they are not doing the matter, but the speaking order part, somehow it has. Lordship will have it on the
Heard the
27th along with the
counsels
other matter. I'll have my instruction.
for the parties. Mr. Patiri appears for the petitioner, Mr. Mazumdar for the respondent. Mr. Mazumdar, please for some time to obtain clear instruction in the matter. Please again on date. When was
In
the
the
other?
earlier occasion, my lord, 360 also appeared, my lord. 23rd
22nd.
one. my lord.
The Agor matter. Last matter, 22nd. List on 22nd.
My lord. Obliged.
Yes, Your Honor. It's an application for restoration of
Restoration.
reputation, Your Lordship. What has happened, Your Lordship, on 2 occasions we were not present, Your Lordship. We had missed the item. Earlier, diligently we were taking steps, Your Lordship. Only last 2 occasions. Your Lordship may kindly condone the lapse on our part and restore the matter to its original. memory. At paragraph 3, I have stated.
Any objection?
No, sir, we have no objection.
Hard learned counsels for the parties, application has been filed, praying for recall of the order dated 3/003/2023 passed in WPC so and so, by which the matter was dismissed for non-prosecution and for restoring the writ petition to file. Learned counsel for the petitioner submits that for reasons beyond his control, he could not appear in the matter. Therefore, the matter came to be dismissed for non-prosecution. The grounds urged in the IA in support of his contentions are as under. There are 4, 5, 3, 3, 4, 5. Stop. There are Mr. Gugoi learned counsel appearing for the respondents does not seek to object to the prayer speech. There are upon hearing the learned counsels for the parties and upon hearing the record. This court will review that grounds urged has sufficiently, the delay that had occurred has been sufficiently urged. Delay that had occurred has been sufficiently explained in the grounds urged. Considering the grounds urged in the IA, this court is inclined to recall the order dated 3/003/2023, dismissing the writ petition number 2902 of 2016 for non-prosecution. Stop. The order dated so and so is hereby recalled. Consequently, the writ petition paying WPC number so and so is restored to file. So I accordingly stand allowed and disposed of. Copy of the order dated so and so be kept in the case record of WPC 2902/2016. In WPC 2902, take down that in view of the orders passed in Miss Case 28 of 23, recalling dismissal, not prosecution. The writ petition stands restored by. So accordingly, the writ petition will be listed for admission. We were pleased. After 1 week, after 1 week.
Yes, your lordships, we have discussed with our client that your relief has not been done. At this stage, your relief has not been granted because there are already the mills has been non-operating. And he has told me that since due to delay, though he is having a very right over the matter, so he is reluctant to. But the thing is that I pray before his honorable court to dispose of the matter, you know.
What dispose of? If you're not pressing it, why dispose of? Mr. H. Borua, learned counsel for the petitioner on instruction. Submits the writ petition, writ petitioner does not wish to press the writ petition any further.
And liberty may be granted, your lordship.
What liberty?
Lordship, if anything remains comes.
Then anything will be a new cause of action. You
Your
don't.
lordship,
liberty.
then that can be kept open, you know.
No, new cause of action will be there. Who's appearing for the respondent?
Standing counsel,
All right.
understand,
Writ petition accordingly stands dismissed as not pressed in order if any stand negated.
lordship. And liberty, your lordship.
What liberty? What liberty? Is not urged. If you want liberty, you file a review. Later on. You won't. Well,